Hi, good evening, everyone. Right. So my name is Jatin, and I'll be taking your classes for the Polity section for PT365, and we'll have 4 classes for this particular part of the Polity that we are going to be covering. So this is for the month of April, March 2022 to December 22 coverage. That is, those are the months that have been covered in the material which you have been given access to and which you'll be referring to in the class as well. For the rest of the months, we'll be coming out with another updation in a few weeks, and then we'll have classes for that particular portion of the current affairs as well. So, one thing which I want to clarify here at the outset is that I hope that you people have seen the kind of questions that have been asked in the prelims examination in the past, and you have already been solving or have been trying to solve those questions that have been asked in the past in last 10 years or so, since the pattern of the examination has changed, and you would have seen the kind of questions as far as polity section is concerned. So if you look at the kind of questions which are asked in polity section, they are usually oriented towards the basics, and even if there is something which has been in the news, the UPSC tends to not ask so much about the event. There may be a few questions where they may ask you some things related to current affairs directly, but as far as the polity section is concerned, questions would be largely very basic in their content. So what we would be doing in the class is that we would try to understand the basics. We would try to understand and revise whatever we have discussed, as some of you may be students of the classroom program, or otherwise as well, something which you would have covered generally as a part of a basic preparation for polity. Because you have to remember that the prelims examination is slightly different as compared to the mains examination. In mains examination, there may be a lot of questions which may be directly asked from current affairs. In the prelims examination, on the other hand, usually what they tend to do is they draw inspiration from the prelims, from the current affairs, and then they make certain basic questions. So let's say if there is news related to the collegium system, then they may ask a question related to the functioning of the collegium system in the exam. Or if the election of the president of India has been in news, if there has been something very specific which has come in the news, they may ask that. Or generally, usually, their attempt would be to ask questions related to the election of the president of India. So there will be some basic questions related to the election of president of India. So that's how UPSC usually tends to frame questions in the polity section. There you would see very few questions which are asked directly, that when did this happen or what happened, etc., and all of that. Those what kind of questions are not asked in the prelims exam? Questions will be conceptual. Questions will be trying to check your basic knowledge only about that particular topic. Right. So we'll begin our discussion. We have quite a few topics to cover. I'll try to ensure that even for those of you, those who haven't attended our classroom program, those who haven't been taught by us, you can just get a good revision of whatever concepts that are oriented towards the current affairs this year, so that that kind of serves not only in terms of giving you a coverage of the current affairs, but most importantly in terms of the basic of the topic as well, the way it can be asked in the prelims examination. So, and our focus will be largely on understanding the concept. We will not go so much into analysis, something which is required from the perspective of the mains examination. Say for example, when we discuss about EWS reservations, now what are the effects of EWS reservation, or critically analyzing the judgment of the Supreme Court of India in the EWS reservations case, or what were some of the arguments which are given by the dissenting judges in the court, etc., is not what is going to be our focus. Our focus would be to understand the basics related to this particular topic. Okay, so the first topic that we begin with for this year's polity section for PT365 is the reservations for the economically weaker sections of the society. So, related to this, you need to understand a few things. Okay, one, what are the type of questions that may be possibly be asked related to the reservations for the economically weaker sections? So, one is that we need to understand a few things. And what are the provisions which are there in the Indian Constitution that are talking about provisions? So, Article 15 and Article 16, both of which are part of right to equality, they include provisions related to reservations. You know, Article 15 is generally talking about equality within India, and Article 16 says that there shall be equality as far as the government jobs, as far as the government positions are concerned. So, Article 16 is equality with respect to appointments in government jobs. And Article 15 of the Indian Constitution is generally about right to equality, and that the state shall not discriminate against a citizen on the grounds of religion, race, caste, sex, etc. So Article 15 और Article 16 का एक basic हमें understanding होना चाहिए. Second thing which we also need to know is, if we specifically look into grounds which have been mentioned in Article 15 and 16 on the basis of which discrimination is prohibited by the state, those grounds should be known to you. For example, in Article 15 of the Constitution, the grounds that have been mentioned on the basis of which the state shall not discriminate against any citizen would be religion. Yes, what else? Caste, sex, and place of birth, right? So you should know these basic grounds on the basis of which discrimination is prohibited under Article 15. When we talk about Article 16, two more grounds get added here. So what are those two grounds? Yes, descent and residence. Descent and residence are the two other grounds which get added as far as Article 16 is concerned, on the basis of which discrimination is prohibited in India as far as the government jobs are concerned. Now, what you need to do, though, keep in mind is that there is Article 16 Clause 3 of the Constitution as well, which is an exception to this principle. So, there is an exception to this particular principle, that there can be no discrimination on the basis of the residence of a citizen in terms of the government appointments. Exception is in form of which article? Huh? What? 16 clause 6. What constitution have you been reading? Article 16 clause 3. Right? So Article 16 clause 3 states that only the Parliament of India has the powers to prescribe that residence can be made a ground for seeking specific kind of government jobs and appointments in a state or a UT. But only Parliament has these powers. So Article 16.3 is an exception to the provisions of Article 16, which says that there may be discrimination on the basis of residence of an individual, that jobs, government jobs in a state, may be reserved only for the people of that particular state, or government jobs in a particular UT may be reserved for people those who are resident in only that particular UT. But such a power to make a law is only with the Parliament, right? So only parliamentary law can provide for this kind of discrimination, which has been allowed as an exception in the form of Article 16.3. Also, do remember that the provisions of Article 16 of the Constitution, which guarantees equality with respect to appointments in government jobs, is only applicable to the government jobs, is only applicable to public positions. It is not applicable to private offices. So do remember that as well, that as far as this is concerned, Article 16 is not applicable to private sector jobs, है ना? वहां पे फिर दूसरा लिमिटेशन आता है, जैसे कि हरियाणा के अंदर इफ 75% रिजर्वेशन हैज बीन प्रोवाइडेड टू द लोकल रेजिडेंट्स इन सर्टेन काइंड ऑफ जॉब्स as per a law made by Haryana state legislature, then the challenge which has been made against that law, and that matter, by the way, is sub judice in the court, is on the grounds of Article 19(1)(g) of the Indian Constitution, which is right to freedom of trade, profession, and occupation, and not Article 16, because Article 16 is only guaranteeing you equal opportunity, is only guaranteeing you equality in matters of government jobs, in matters of government appointments, not in case of private sector jobs. So please do keep that particular thing also in mind. Now, this is one broad aspect of 16. 15 also you should be knowing. For example, 15(1) should be known to you. है ना, which says that the state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, basis on basis of place of birth, etc., and all of those things. Article 15 clause 2 on the other hand says that no citizen shall be discriminated against with respect to entry into any places which are public in nature. Any place which is public in nature, any place which is generally meant for the use of the public, or any place which has been maintained fully or partially out of state funds would be called as a public place. Article 15.2 says that there can be no discrimination, no kind of disability that can be imposed on any citizen of India, either by the state or by some other individual, with respect to entry into any such public places, which would include places such as the public tanks, which would include places such as public restaurants, which would include places such as parks, etc. In such places, there can be no discrimination on the ground of a person's religion, race, caste, sex, place of birth, or any of them. Do remember, this is not applicable to private restaurants. So in a private restaurant, in a private bar, if they do not allow you to enter into the restaurant, it is well within their rights to do so. Why? Because Articles 15 clause 2 is not applicable with respect to discrimination in case of private places. One may discriminate entry or on the entry into a particular place on the basis of religion, race, caste, etc., and that would not be a violation of 15.2. Another article that you should know about is 15.3. What does 15.3 says? Yes, special provisions can be made for women and children by the state. So it is also an exception to Article 15 of the Indian Constitution. Then these are the basic provisions, है ना? 15.1, 15.2, 15.3, 16.1, 16.2, 16.3, basic provisions. Other than that, there are provisions which are there in the Indian Constitution that enable the state to provide reservations either in educational institutions or to provide reservations in government jobs. So what are those provisions? So let's talk about the reservation provisions now, which is the point of discussion here, and then we'll understand about. So as far as the reservation provisions are concerned, one relevant article is Article 15.4 of the Constitution. Which was the Constitutional Amendment Act which added this particular article? Right. So first Constitutional Amendment Act से particular article add हुआ. Article 15 clause 4. Article 15 clause 4 says that the state can make special provisions in the favor of the SCs, STs, and the socially and educationally backward classes of citizens. So according to 15.4, special provisions can be made for SCs, STs, and socially, educationally backward classes of citizens. Right? This is 15.4 of the Constitution. इसी के अंदर SCs और STs को reservation दिया गया. Till 2005, reservations had been provided to the scheduled caste and the scheduled tribes in educational institutions as per Article 15.4 of the Indian Constitution. फिर आपको 15.5 के बारे में भी पता होना चाहिए, है ना? Article 15.5, which was the Constitutional Amendment Act that added this article? कौन सा? Why do I hear only one or two students responding? Rest don't know about all of this. How many of you have studied at foundation batch here at Vision? आप में से कितने लोग यहाँ पे आए हैं foundation batch में? बस that many? What about rest? You are attending just the PT365 program. So you don't know about what is 15.5 of the Constitution? Yes. What does 15.5 say, sir? Yes. So the state can make reservations, but it says the state by law can provide reservations. यहाँ पे 15.4 में वो law की बात नहीं करता है. 15.5 of the Constitution was added by the 93rd Constitutional Amendment Act, 2005. है ना? 15.5 of the Constitution says that the state by law. अब state का मतलब state नहीं है उत्तर प्रदेश, मध्य प्रदेश. State means state of Article 12, which would include Parliament as well as the state legislature, which would include basically the center and the union or the state, है ना? दोनों होंगे उसके अंदर इंक्लूडेड. सो आर्टिकल 15(5) says that the state by law can provide reservations in educational institutions for the SCs, STs and the socially and educationally backward classes of citizens. Now, if I read out Article 15(5) of the Indian Constitution for you, see, you should know these articles by heart if you have to do well in any exam, whether it is prelims or mains. 15(5) says that nothing in this article or in subclause G of Article 19(1)(G, basically 19(1)(G) can also be a restriction, shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens or for scheduled castes or scheduled tribes insofar as such special provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions. So, the point which you need to keep in mind here is that Article 15(5) is an enabling provision. Enabling provision का मतलब समझते हैं सब लोग? हाँ, enabling provision का मतलब समझते हैं? क्या होता है enabling provision का मतलब? Sorry, doesn't place a restriction. Yes, it enables the state or it enables someone to do something. It is not necessarily providing reservations. Please understand that. 15(5) है तो इसका मतलब ये नहीं है reservations होंगी. 15(5) is saying that the state by law. So Article 15(5) is stating that state by law. है ना, state मतलब Article 12 वाला state है ये. State by law may provide reservations in educational institutions for SCs, STs and socially educationally backward classes of citizens. Please remember that these provisions for reservations may extend to private institutions as well. अभी तक किया नहीं गया है बट किया जा सकता है. It may extend to private educational institutions also. उससे कोई फर्क नहीं पड़ता whether they are aided by the state or unaided. चाहे उनको सरकार से मदद मिलती हो, whether they get any kind of help or support from the state or not, there can be reservation provisions that can be made for the private educational institution as well. Exception though under 15(5) is that there would be no reservations in educational institutions. In which institutions? Right? In minority educational institutions under which article? Article 30 of the Constitution. 29 कहां से आ गया? Article 30 of the Constitution. Minority educational institutions are set up under Article 30, है ना? क्योंकि 29 और 30 को हम साथ में पढ़ते हैं तो हर जगह जहां पे 30 लगता है वहां पे 29 बोल दें हम, that is not going to get you marks, है ना? वहां पे अगर वो आपको क्वेश्चन देता है माइनॉरिटी एजुकेशनल इंस्टीट्यूशंस कहां पे मेंशन्ड है तो इट इज ओनली आर्टिकल 30, इट इज नॉट आर्टिकल 29. yes, article 29 and 30 are supposed to be read together. They are cultural and educational rights, but that doesn't mean that Ram is Sham and Sham is Ram, right? It doesn't mean that 29 and 30 are the same. Please don't confuse both of them. दोनों को confuse मत कीजिएगा please. ठीक है? So article 30 talks about minority educational institutions in India. इन एजुकेशनल इंस्टीट्यूशंस में कोई रिजर्वेशन प्रोविजंस नहीं लगेंगे जो SC, ST, OBCs को लगते हैं. ऐसा क्यों? बाय व्हाट वुड बी द रीजन बिहाइंड दिस? कोर्ट की जजमेंट है ये, है ना? दिस इज द जजमेंट ऑफ द कोर्ट. ऐसा क्यों है? ये सर बट ऐसा तो नहीं है कि मतलब उसमें मेजॉरिटी कम्युनिटी के लोग नहीं आते माइनॉरिटी एजुकेशनल इंस्टीट्यूशंस में. ये किसने बोल दिया तुम्हें? एक मुस्लिम रन इंस्टीट्यूशन में हिंदू जाके एडमिशन नहीं ले सकता क्या? या एक क्रिश्चियन रन इंस्टीट्यूशन में मुस्लिम नहीं जाके एडमिशन ले सकता? ऐसा नहीं है, कुछ 50% ही होती है, जरूरी नहीं है. डिपेंड्स ऑन द स्टेट. जरूरी नहीं है, जरूरी नहीं है. हाँ. See, actually the reason is in minority educational institutions they are already serving a social purpose. वो ऑलरेडी एक सोशल पर्पस सर्व कर तो रहे हैं, माइनॉरिटीज को रिजर्वेशन प्रोवाइड करने का या माइनॉरिटीज को अपने खुद के इंस्टीट्यूशन चलाने का और वहां पे सीट्स रिजर्व करने का. देखिए 50% एंड ऑल दैट इज नॉट समथिंग विच इज डिटर्मिन्ड. यू हैव टू अंडरस्टैंड after the judgment of the court in multiple cases, if you read TMA Pai case, if you read PA Namdar case, the position is that as far as minority educational institutions is concerned, the reservation limit, whether it should be 50 or 60 or 90 for the minorities, would be determined by the state government, and that would depend upon a number of factors. For example, in the TMA Pai case, the court has stated that in minority educational institutions which are teaching only primary education, in those institutions you can even reserve up to 90% of the seats for minority. But in higher educational institutions, let's say कोई engineering college आप run कर रहे हैं, minority educational institution, in that institution there should be reservation should be limited because higher education की बात हो रही है, आप लिमिट कीजिएगा वहां पे रिजर्वेशन, है ना. तो जरूरी नहीं है मैम कि 50% ही हो. एनीवे, द पॉइंट इज दैट माइनॉरिटी एजुकेशनल इंस्टीट्यूशंस आर एक्सक्लूडेड फ्रॉम प्रोवाइडिंग रिजर्वेशंस अंडर 15(5) ऑफ द इंडियन कॉन्स्टिट्यूशन. अब साथ ही साथ एक और चीज पढ़ लेते हैं, बिकॉज इन योर पीटी 365 मटेरियल यू वुड ऑल्सो फाइंड, मैं पूरा ना रिजर्वेशंस के टॉपिक से जो भी सब कुछ रिलेटेड बेसिक रिविजन आप लोगों का करवा सकता हूं वो करवा रहा हूं. सो as far as the minority educational institutions under Article 30 of the Indian Constitution are concerned, what you need to keep in mind is that what is the definition of the term minority, है ना. minority define कैसे होगी? So Article 30 only gives us a clue. On what basis can the minority be segregated according to the Indian Constitution? One is religious basis, है ना, and the second one is linguistic basis. दो तरीके से माइनॉरिटी का आइडेंटिफिकेशन हो सकता है, रिलीजियस एंड लिंग्विस्टिक माइनॉरिटी. ये अपने एजुकेशनल इंस्टीट्यूशन सेटअप कर सकते हैं. आर्टिकल 30 says they have right to establish and administer educational institutions of their choice. Of their choice means that these institutions may even impart secular education or religious education. इसके ऊपर कोई पाबंदी नहीं है. So such minority educational institutions may even, so what kind of education can they impart? It can be both, है ना. सेक्युलर एजुकेशन का मतलब है इंजीनियरिंग कॉलेज स्टार्ट किया हुआ है, एमबीए कॉलेज स्टार्ट किया हुआ है, मेडिसिन कॉलेज स्टार्ट किया हुआ है, और अदर वन कुड बी रिलीजियस एजुकेशन एज वेल. इन इंस्टीट्यूशंस को एग्जेम्पशन दिया गया है आर्टिकल 15 क्लॉज 5 में. ईडब्ल्यूएस के अंदर भी इनको एग्जेम्पशन दिया गया है. इवन इन दी इकोनॉमिकली वीकर सेक्शन के लिए जो रिजर्वेशंस हैं, दोस डू नॉट एक्सटेंड टू माइनॉरिटी एजुकेशनल इंस्टीट्यूशंस अंडर आर्टिकल 30 ऑफ द इंडियन कॉन्स्टिट्यूशन. राइट, सो दैट इज अनदर थिंग विच यू नीड टू कीप इन माइंड एज फार एज द माइनॉरिटी एजुकेशनल इंस्टीट्यूशन कंसर्न. अच्छा, दूसरी बात ये, हाउ इज माइनॉरिटी सपोज टू बी डिटर्मिन्ड, वेदर Hindus will be minority or whether Muslims will be minority or Christians will be minority or Telugu speaking will be minority or Tamil speaking will be minority? How would that be decided? No, it is supposed to be decided at the state level, है ना. ये स्टेट वाइज डिटर्मिनेशन होगा माइनॉरिटी का, कोर्ट की जजमेंट है, ठीक है. सो टू डिटर्मिन वेदर अ पर्टिकुलर कम्युनिटी is minority or not would be determined on the basis of state. For example, Christians will be a majority in Mizoram, Hindus will be a minority there, right? In J&K, Hindus will be a minority. In Punjab, Muslims will be a minority. So it depends on state, not on the basis of the nationwide numbers, है ना. So that is Article 30 of the Indian Constitution. Determination of a minority status for a community would be done on the basis of statewide numbers, state census. Also, you must keep in mind that the reservation provisions under 15(5) and 15(6) for the economically weaker sections under 15(6) and generally for the socially educationally backward classes and for SCs and STs do not extend under 15(5), do not extend to minority educational institutions. Now, so this is about as far as the provisions of 15(4), 15(5) are concerned. Now, let's quickly look at the provisions of 15(6) as well, which is the point of discussion as per your material. and which has now been upheld by the Supreme Court of India as well. So it's the 103rd Constitutional Amendment Act 2019 which added this provision. It also added Article 16(6) of the Indian Constitution. इससे दो आर्टिकल ऐड हुए 15(6) और 16(6) है ना. 15(6) allows the state to make a law and to provide reservations for the economically weaker sections of the society other than the SC, ST and OBC. Basically for the unreserved, उनके अंदर जो इकोनॉमिकली वीकर सेक्शंस होंगे उनके अंदर मैक्सिमम 10% तक की रिजर्वेशन दी जा सकती है. सो इफ आई रीड 15(6), nothing in this article or subclause G of 19(1) or clause 2 of article 29 shall prevent the state from making any special provision for advancement of economically weaker sections of the citizens other than the classes which are mentioned in clause 4 and clause 5. ठीक है. तो क्लॉज 4 और क्लॉज 5 में कौन मेंशन है? सोशली एंड एजुकेशनली बैकवर्ड क्लासेस एंड SC, ST. उनके अलावा इकोनॉमिकली वीकर सेक्शंस के अंदर रिजर्वेशन दी जा सकती है. देन इट सेज दैट एनी स्पेशल प्रोविजन फॉर द एडवांसमेंट of any economically weaker sections other than classes mentioned in 4 and 5 insofar as such provisions relate to their admission to educational institutions including private educational institutions whether aided, unaided, etc. other than minority educational institutions referred to in clause 1 of article 30 which in case of reservation would be in addition to the existing reservations and subject to a maximum of 10%. अब कितना exact reservation दिया जाएगा that would be decided by the state government or by the center, है ना. So 15(6) of the constitution is allowing, it is also an enabling provision. It enables the state, स्टेट विद अ कैपिटल एस लिख रहा हूं मैं, प्लीज ध्यान रखिएगा इसको, है ना. enables the state to make reservations for the economically weaker sections, to make reservations for the economically weaker sections up to 10%. Please remember one thing, this does not extend to minority educational institutions under article 30 of the Indian Constitution. ठीक है. So this is as far as article 15(5), 15(6) and 15(4) and provisions related to reservation in educational institutions are concerned. साथ ही साथ you should also remember one more relevant article, है ना. एक और आर्टिकल हमें पता होना चाहिए which is article 29 clause 2. ये क्या कहता है? What does 29 clause 2 say? There cannot be any discrimination with respect to admission into educational institutions which are funded fully or partially by the state. जो state run educational institutions हैं उनमें discrimination नहीं हो सकता किसी citizen के खिलाफ. Article 29 is available only to the citizens of India. Article 29 clause 2 उसके अंदर grounds mentioned हैं जिसके basis पे discrimination is prohibited. What are the grounds on the basis of which discrimination is prohibited with respect to admission into educational institutions under Article 29 clause 2? Religion or race, caste, language. Very good. Or religion, race, caste, language. What else? Is sex there? लोग कह रहे हैं हाँ sex है. Sex नहीं है भाई. Sex is not included as a, so there can be discrimination basically on the basis of sex. In government aided or government run educational institutions, है ना. Probably for promoting girls education, if the state wants to make some kind of a special provision then they would be enabled to do so, because sex is not mentioned as a ground on the basis of which discrimination is prohibited with respect to admission into educational institutions under Article 29 Clause 2 of the Indian Constitution. Is that clear to everyone? ठीक है? Is this clear? आगे चलें? अरे सांप सूंघ गया क्या भाई? आगे चलें? ठीक है. So now let's talk about Article 16. देखो एग्जाम है, इसका मतलब ये नहीं है कि इतना स्ट्रेस में आ जाओ कि एग्जाम में जाने से पहले ही जो है खत्म हो जाओ, है ना? Please understand one thing, you have to be in the right frame of mind as well if you want to do well in this examination. So put all the baggage behind, है ना? आपने कितना अभी तक पढ़ाई किया, नहीं किया, क्या टाइम वेस्ट हुआ, क्या नहीं हुआ, none of this matters now. What ultimately will decide is how many questions you can solve in the prelims exam. और मैं आपको ये बात बताना चाहता हूँ, for those who may think कि हमने ज़्यादा मेहनत नहीं करी है, नहीं करी तो अभी भी कर लो. It's still not too late, है ना? बहुत ज़्यादा लेट नहीं हुआ है. अभी भी there are 3 months there are which you have, and believe me 3 months can literally change the attempt, है ना? Prelims examination वैसे ही लॉटरी है, देखिए. Unfortunately, because the kind of margins which are there in the prelims exam, even after doing a lot of preparation, you can still fail. So, for those of you who may be underconfident or those who are feeling anxious, especially, anxiety सबको है. जिसके 150 नंबर आएंगे उसको भी एंग्जाइटी है, और जिसका जस्ट मार्जिन पे क्लियर होगा उसको भी एंग्जाइटी है. प्लीज अंडरस्टैंड दिस. रीजन फॉर दैट इज बिकॉज द एग्जाम इज सच. आपकी कितनी भी तैयारी हो, आप पहले ये एग्जाम निकाल भी चुके हो, आफ्टर दैट ऑल्सो यू वुड बी एंग्शियस फॉर द प्रीलिम्स एग्जाम. सो प्लीज try to be as positive as possible, and try to keep yourself mentally fit. That is the most important thing, because in those 2 hours you have to solve as many questions correctly as possible. That is what is the objective. और कुछ नहीं है. क्या फर्क पड़ता है कितनी पढ़ाई की थी, नहीं की थी, कितना नोटबुक्स पढ़े, कितने बुक्स पढ़े, कितने नोट्स बनाए, कौन सी क्लासेस अटेंड करी. नन ऑफ दिस मैटर्स. Ultimately what matters is if you can solve 60-70 questions there with 80-90% accuracy in the prelims exam out of 100. That is what is the real deal, है ना? उसी के ऊपर है सब कुछ. रेस्ट नन ऑफ दिस मैटर. आप चाहें उसके बाद आधा नंबर से क्वालिफाई कर जाएं, क्या फर्क पड़ता है? देन वी विल सी इन द मेंस एग्जाम, है ना? सो प्लीज अंडरस्टैंड दैट, है ना? ज्यादा घबराने का कोई पॉइंट नहीं है, और जो हो चुका वो हो चुका. लुक फॉरवर्ड, look at the next 3 months, try to make the maximum use of whatever little time that is available in your hands right now. मार्च एंड अप्रैल का अभी पूरे 2 महीने पड़े हैं आपके पास, एंड देन यू हैव 11 days in this month also. 71 days, 72 days तो you have already, है ना? That believe me is quite a lot. अगर आप तमीज से इन 72 दिनों को भी यूज करें, एंड देन यू जस्ट रिवाइज इन द लास्ट 26-27 days. अगर आप केवल उसमें रिविजन करें, और अगर अभी भी 70 days अगर आप ढंग से तैयारी करें, बिलीव मी इट इज पॉसिबल, है ना? अब बिल्कुल ही आपने कुछ भी नहीं पढ़ा कभी, है ना, एकदम जीरो डब्बा गोल है, तो फिर मेरे को नहीं पता कैसे होता है. बट इफ यू हैव डन इवन डिसेंट अमाउंट ऑफ प्रिपरेशन टिल नाउ, देयर इज स्टिल अ चांस दैट यू कैन क्वालिफाई द प्रीलिम्स एग्जामिनेशन. प्लीज बिलीव मी, है ना? पॉसिबल है. बट यू हैव टू फर्स्ट टेल दैट टू योर सेल्फ. खुद अपने आप अंदर भी सेल्फ बिलीफ होना चाहिए. अगर अभी से ही आप हार मान जाएंगे, बहुत सारे स्टूडेंट्स को मैं देखता हूं, दे आर कंसिडरिंग दैट वी विल ड्रॉप एन अटेम्प्ट. I don't know what kind of sense does it make. Either you must be super rich, your parents must have given you crores of rupees that you have so much time to waste in life, है ना? Or you have been given some kind of a boon by God कि भाई 150 साल तक जियोगे तुम, है ना? 70 की उम्र तक तुम्हारे फेस पे एक झुर्रियां नहीं आएंगी. अगर ऐसा किसी ने आपको वरदान दे दिया तो अलग बात है. अदरवाइज डोंट वेस्ट योर अटेम्प्ट, डोंट वेस्ट योर ईयर. दीजिए एग्जाम, जैसी भी तैयारी है, आधी है, पूरी है, दीजिए. पॉजिटिव फ्रेम ऑफ माइंड के साथ दीजिए. क्वेश्चंस अटेम्प्ट कीजिए जितने हो सकते हैं. एनीवे, सो नाउ आर्टिकल 16 आई हैव डिस्कस, 16.1, 16.2, 16.3. आर्टिकल 16.4 is also an enabling provision. Which constitutional amendment added 16.4? Which constitutional amendment added 16.4 into the constitution? First, this was an original provision of the Indian Constitution, 16.4. It allows the state to make reservations. It's also an enabling provision. Reservations in government jobs, appointments, in the favor of whom? Backward classes of citizens. It does not say SC, ST or etc. and all of those things. in the favor of backward classes of citizens. Right? 16(4) of the Indian Constitution allows the state to make reservations in the favor of backward classes of citizens. Right? So reservations for the OBCs, reservations for SCs, STs in government jobs have been all made under 16(4) of the Indian Constitution. Another thing which you need to keep in mind is that there was one more article which was added by an amendment of the Indian Constitution, which was 16(4)(a). 16(4)(a) क्या कहता है? Yes, reservations can be provided even in promotions. For whom? For SC, ST only, right? So reservations not just restricted to initial appointments, but in promotions as well. For whom? SCs and STs. There are no reservations in promotion for the OBCs. Reservations and promotions only for the scheduled caste and the scheduled tribes under 16(4)(a). ये भी एक दिमाग में रखना है. Then 16(6) was of course added by 103rd Constitutional Amendment Act. This is same replica of 15(6) only. This one is allowing you to make reservations for economically weaker sections up to 10% hai. Maximum is 10%. And this 10% will be in addition to the existing reservation. So the existing reservation for SC, ST, OBC plus 10% reservation for the economically weaker sections from the non-ST, ST and OBC sections of the society. So these are the provisions that you need to keep in mind. Article 15 and Article 16, please go and revise it once. Important for this year's exam. Now, another thing which you also need to keep in mind is that what has been the judgment of the court on this matter. Court has stated that the reservations provided for the economically weaker sections of the society is perfectly fine. So it is well within the constitutional limits and it is not ultra vires or it is not unconstitutional. It is not ultra vires of the constitution or it is not unconstitutional in nature. It is not violating the basic structure of the constitution or principle of equality. सारे ये जो arguments दिए गए थे कोर्ट के अंदर, all of these were rejected by the majority in the Supreme Court. So that is what we need to keep in mind as far as the reservations for the economically weaker sections are concerned. Now, one more thing which you also need to understand here is okay. So one thing which we need to keep in mind is that with respect to reservations in the local bodies. अब ये भी एक बार समझ लेते हैं. Reservations in Panchayati Raj institutions and in the municipalities. So one, you must know that reservations have been made mandatory in panchayats and in urban local bodies for women. Minimum of 33%, maximum maybe anything. In many states, they have provided 50% reservation for women in the panchayats and in the municipalities. So that is one thing which we need to keep in mind. यार एक ना पीडीएफ बोला था मैंने, उनको 2 पीडीएफ बोले थे क्लासरूम टीम को. आप उन्हें बोलिएगा, उनकी मेल आईडी पे है classroom@vision जो भी उस पे है. मैंने 2 पीडीएफ भेजे हैं, वो प्लीज मेरे को पेन ड्राइव पे भेजें अभी वो. ठीक है. सो नाउ आर्टिकल, अच्छा व्हाट वर वी टॉकिंग अबाउट? वी वर टॉकिंग अबाउट, क्या बात कर रहे थे? हाँ, रिजर्वेशंस इन लोकल बॉडी. सॉरी. So, as far as reservations in local body are concerned, for women, reservations are mandatory. Minimum of 33% has to be provided by every state. Second is, another mandatory reservation is for the scheduled caste and for the scheduled tribes. What will be the percentage here? In proportion to their population. है ना? In proportion to their population in that particular constituency. In that wherever, मतलब जिसके भी चुनाव हो रहे हैं, जिला पंचायत के हो रहे हैं या ब्लॉक लेवल के हो रहे हैं, और whether it is the village level पंचायत. in proportion to their population, right? Do remember one thing, that women would be provided horizontal as well as vertical reservation, which basically means that they would be provided reservation separately overall minimum 33%, and even within SC and ST they should have 33% reservation. Matlab agar if there are 9 scheduled caste candidates, those who have been elected in reserved seats, out of them 3 should be, at least 3 should be SC women, है ना? So reservation for women are both vertical as well as horizontal. Please keep that in mind. So overall also it should be 33% minimum, and within the subcategorization as well of SC, ST, etc., there should be minimum 33%. Now, what you need to keep in mind is that reservations for the OBCs are not mandatory. है ना? They have to be made by the state by law. जो भी state legislature है, by law would determine whether reservations should be given to the other backward classes in the local bodies or not, and this also will be in proportion to population. And this also would be in proportion to population of the other backward classes. Is this clear to everyone? ठीक है. Now other thing which you also need to remember here is that अब इसके ऊपर कुछ states में पंगा आया. In Maharashtra, in Uttar Pradesh, Supreme Court has stated that you need to pass a triple test if you want to give reservation in educational institutions. If you want to give reservations in local bodies for the OBCs. तो ये triple test क्या है? So there is a triple test that has been laid down by the Supreme Court, which suggests that if you want to provide reservations in the panchayats or in municipalities for OBCs, then you need to satisfy this triple test. अब ये triple test क्या है? Triple test की पहली condition है that there should be a body that should be created, a commission should be created specifically to look into the conditions of the other backward classes and to determine if they are truly backward or not. अब ये जो backwardness है will not be decided on the basis of their social and educational backwardness, but on the basis of political backwardness, which basically means that are they inadequately represented in the political bodies. ऐसा तो नहीं है that the OBCs in a particular state are not represented properly in terms of their population in the panchayats or in municipalities. So there has to be a commission. This commission has to provide this recommendation that reservation should be made for the OBCs, and that is also another condition. So let's just have a look at this triple test. This has been given in your material also. So what is this triple test? There should be a dedicated commission which should be set up to gather data on backwardness of OBCs in every local body. Backwardness here means political backwardness, does not mean social and educational backwardness. Second, specify proportion of reservation in each body in light of commission's recommendation. So accordingly the state would suggest that okay, this is what the commission has suggested, and therefore we are providing this much reservation, and also total reservation should not exceed 50% of the seats. So SC, ST, OBC का reservation मिलाकर 50% के ऊपर नहीं होना चाहिए, है ना? So that is what the court has suggested as far as reservations in the local bodies is concerned. That's why they have struck down the reservation provisions made in the local body elections in UP, because the law which was made by the Uttar Pradesh government to provide reservations for the OBCs did not satisfy this triple test criteria. इसी वजह से सुप्रीम कोर्ट ने उसको स्ट्राइक डाउन कर दिया. इज दैट क्लियर टू एवरीवन? राइट. सो ये पढ़ लीजिएगा आप खुद से एक बार, है ना. Largely this is what we need to keep in mind as far as the reservation provisions are concerned. Also what you need to keep in mind is one question has already been asked on NCBC in the mains exam, so it automatically becomes important for prelims exam also. So what was the Constitutional Amendment Act according to which the National Commission for Backward Classes was set up? Which is the relevant provision of the Indian Constitution? Who are the members of the NCBC? And how are the members of the NCBC appointed, what is their tenure, etc., and all of those things, वो पढ़ लीजिएगा please आप. Now, another topic which we need to keep in mind is related to this is that there was a commission which was made by the government of India on the recommendation of National Commission for Backward Classes, which is called as the Justice Rohini Ji Commission. This has been set up under Article 340 of the Indian Constitution. 340 पे भी सवाल आ सकता है आपको. What is 340? 340 states that the President of India may form a commission to examine the condition of the socially and educationally backward classes of citizens and to provide recommendations so as to improve their conditions. So if you would know about Mandal Commission, BP Mandal Commission, which recommended reservations for OBCs, है ना, in the government jobs, that same commission was also appointed under Article 340. इसके लिए बस president को एक order sign करने की जरूरत है, and then commission can be set up. This commission would be given the task of examining the condition, situation of the OBCs, actually socially and educationally backward classes of citizens, and what are the measures that should be taken in order to improve their situation. So this Rohini Ji Commission was set up on the recommendation of the National Commission for Backward Classes. What is this Rohini Ji Commission, Justice Rohini Commission supposed to do? Within the OBCs, it has been seen that only a few communities are able to corner all the benefits of reservations either in educational institutions or in the government jobs. So there is still a section of the other backward classes which remains to be really backward, despite reservation provisions being enforced. So now the study which this commission is supposed to do is to identify the criteria and also identification of 3 subcategories of OBCs. So these 3 subcategories of OBCs would include extremely backward classes, would include more backward classes, and would include backward classes. So on the basis of these 3 categorization, the commission would recommend that okay, how much of this 27% reservation should be divided between the 3 categories, 3 subcategories. है ना. तो ऐसा हो सकता है कि कमीशन रेकमेंड करे कि 27% में से 17% रिजर्वेशन शुड गो टू दी मोस्ट backward classes, sorry, extremely backward classes. Then perhaps 7 or 8% should go to more backward classes, and maybe 2 or 3% may go to backward classes. We don't really know what the commission would suggest, but this commission's tenure has been extended from time to time by the government. So see, what is the mandate of this commission? Examine the extent of inequitable distribution of reservation benefits for the OBCs amongst the OBCs and identification of these 3 categories and work out the mechanism, criteria, norms, etc. for subcategorization of OBCs. किस basis पे subcategorization किया जाए, किसको कितना % reservation दिया जाए, किस subcategory को, all of this would be determined by the Justice Rohini Commission. This is what you need to keep in mind, right? As of now, there is no categorization, subcategorization, but there may be subcategorization in future upon the recommendations given by Justice Rohini Commission. Please keep that in mind. Okay, so this is broadly about the first 2 topics which have been given in your PT365 for this year. Can we proceed further? Right, now let's move on to the next topic. This one is about the Uniform Civil Code. So first you must know what is the Uniform Civil Code, which is the provision of the Constitution that talks about the Uniform Civil Code, what is the status of Uniform Civil Code in India, है ना? So first let's talk about यूनिफॉर्म सिविल कोड. तो इंडिया में जो पर्सनल लॉज हैं, है ना, पर्सनल लॉज स्पेशली रिलेटेड टू मैरिज, डिवोर्स, adoption, maintenance, all of these laws vary according to the religion you practice. Otherwise, generally, what is the system which is there? That in case of the criminal laws, we have same criminal laws. In case of constitution, we have the same constitution. है ना? But as far as the provisions related to the personal laws are concerned, they vary according to the religion that you practice. Hindu marriage, for example, if two Hindus marry each other under the Hindu Marriage Act, is supposed to be governed by Hindu Marriage Act of 55. If there is an interfaith marriage that is happening in India, let's say between a Muslim and a Hindu, between a Muslim and a Christian, in that case, there would be a special marriage act which would come into place. So, according to different religion, अगर आप Christian हैं तो आपकी जो marriage है that would be regulated by the Christian laws. Divorce would be regulated by Christian laws. If you are a Muslim, then your marriage, divorce, adoption, etc. would be regulated according to the Muslim laws. So in India, India lacks a uniform set of laws for personal matters for the people of different religion. ठीक है. यूनिफॉर्म सिविल कोड क्या कहता है? दैट फॉर द पर्सनल मैटर्स सच एज मैरिज, डिवोर्स, एक्सेट्रा, there should be a single set of laws that should be applicable irrespective of whichever religion you belong to. Whether you are a Hindu or a Muslim or a Christian or a Sikh or a Parsi, it does not matter. You would be regulated according to the same set of laws. Your marriage, divorce, etc. everything would be same. Because इसका देखिए बड़े सारे reasons हैं. One is that if India is saying that we are a secular country, we are a secular state, then why should there be separate laws for separate people? Why should there be different set of laws for people belonging to different religions? That is one. Second problem which is there is that it leads to confusion, it leads to chaos as well. है ना? Third problem, अब implementation भी तो problem हो जाएगा अगर multiple set of laws होंगी तो courts के लिए भी it's a problem. The third big problem with not having a uniform civil code is that many of the laws, religious laws, are discriminatory, especially against the women. They are discriminatory against women. For example, अगर आपने हिंदू मैरिज एक्ट पढ़ा हो, उसमें डिवोर्स के बड़े सारे कारण होते हैं ना. A husband or a wife can seek divorce from the other on various grounds. One of those grounds is cruelty, which is physical or mental cruelty. If your spouse is being cruel to you, either in physical terms or in mental terms, mental torture or physical torture, something like that, in that case, you can approach and you can seek a divorce on the grounds of cruelty. Now, the interesting thing is that for the longest time in the Christian law, there was no way that a woman could seek divorce from her husband on the grounds of cruelty. If you are a Christian woman, if you were a Christian woman, married under Christian laws, then you could not seek a divorce from your husband on the grounds of cruelty. There was no provision which existed in the Christian laws. So this is discriminatory against women. है ना? The triple talaq judgment of the Supreme Court of India, again, triple talaq provisions discriminatory against women. Why only women? Even women should be allowed to give divorce to men. है ना? So the point that I'm trying to make is that uniform civil code is definitely a desired principle in India, that we should have uniform set of personal laws in India. Now, Article 44 of the Indian Constitution. Hanji. Where? मेरे को दिखा नहीं ना, इसलिए तो बोला मैंने. कहाँ है? हाँ, इसको कॉपी कर दो. ठीक है, थैंक यू. So Article 44 of the Indian Constitution, that is a directive principle of state policy, which is not an enforceable mechanism. ये enforceable नहीं है ना? और it is not enforceable on its own at least. If the state wants, it may enforce DPSPs, but they are not legally enforceable on their own. अपने आप से legally इनकी कोई value नहीं है. Directive principle of state policy, Article 44 of the Indian Constitution says that the state shall endeavor to secure a uniform civil code for all the citizens in India. अब देखिए ये जो बिल है, इस बिल का क्या प्रोविजंस हैं? एकदम बिल्कुल बोगस डिबेट है ये, जो अभी सी दिस इज जस्ट अ वे टू क्रिएट कंट्रोवर्सी, और कुछ नहीं तो कोई नई न्यूज बना दो, है ना। न्यूज चैनल्स को और बहुत बार वेस्टेड एलिमेंट्स को क्या चाहिए कि लोगों का ध्यान भटकाया जाए, कोई बड़ी प्रॉब्लम हो रखी है तो उससे इफ यू हैव टू डिस्ट्रैक्ट पीपल तो कुछ नई न्यूज बना दो, है ना। किसी एक्टर के बेटे को पकड़ लिया कितने ग्राम ड्रग्स के साथ, ये न्यूज बना दी, है ना। किसी का कोई कुत्ता मर गया कहीं पे, ऑल दोस काइंड ऑफ नॉनसेंस काइंड ऑफ थिंग्स वुड बी स्प्रेड। अब ये भी वही है, दिस प्राइवेट मेंबर बिल फर्स्ट एंड फॉरमोस्ट, एक तो आपको ये पता होना चाहिए इंडिया में पिछले 50 साल में कोई प्राइवेट मेंबर बिल पास नहीं हुआ है, तो ये कैसे पास हो जाएगा। देयर इज नॉट इवन अ सिंगल प्राइवेट मेंबर बिल विच हैज बीन पास्ड। सेकेंड थिंग इज दैट वैसे तो प्राइवेट मेंबर बिल इंट्रोड्यूस भी नहीं हो पाते हैं, ये वाला इंट्रोड्यूस इसलिए हो गया बिकॉज गवर्नमेंट सपोर्ट था इसको, है ना। अब ये प्राइवेट मेंबर बिल कह क्या रहा है, क्या कह रहा है ये प्राइवेट मेंबर बिल, यूसीसी वाला, यूसीसी के प्रोविजन बता दिए हैं इसने। व्हाट इज दिस बिल सेइंग, व्हाट आर द प्रोविजंस ऑफ दिस बिल, पढ़ा होगा ना न्यूज में। हम्म बस वो कह रहा है जी एक एक्सपर्ट बॉडी बनाइए जो कि कंसेंसस बिल्ड करे यूनिफॉर्म सिविल कोड लाने के लिए देश में, और वो स्टडी करे कि कैसे यूनिफॉर्म सिविल कोड इंप्लीमेंट हो। कोई नई चीज कह दी कोई बड़ी, ये तो बहुत सालों से बात चल रही है। लॉ कमीशन ऑफ इंडिया in its multiple reports has already suggested that uniform civil code is neither desirable at this stage nor is it even possible at this stage. See, you will have to build a social consensus in the society. You will have to take people on board. आप जबरदस्ती लॉ थोप देंगे लोगों के ऊपर और लॉ मानना शुरू कर देंगे लॉ अगले दिन से लोग, ऐसा नहीं होने वाला देश में, है ना। Not all the laws are enforceable. You have to change the attitude of the society as well. For that, there has to be a consensus within various communities. एंड दैट इज अ वेरी लॉन्ग ड्रॉन प्रोसेस, वो बड़ा लंबा प्रोसेस है, उसके लिए हमें सबको साथ में लेके चलना पड़ेगा। we'll have to build that consensus, we'll have to take a very democratic approach if we actually want to implement uniform civil code in India. Otherwise all of this is just a nonsense kind of a talk. It's very difficult to implement, very difficult to enforce, because there will be a lot of pushback from different sections of the society. People just talk about one minority, there are multiple other minorities in the country who will object to this. The scheduled tribes will also object to this. You see this? देखिए आप. What will happen to Nagas? What will happen to the Mizos? You must be knowing we have given them protection 371A, 371G. Laws of Parliament related to the customary laws of Nagas and Mizos would not apply to Nagaland and Mizoram unless they have been given approval by the Naga State Assembly or the Mizo State Assembly. तो अब कहाँ की बातें कर रहे हैं हम, है ना। ऑल ऑफ दिस इज जस्ट smoke which is created in order to distract people, unfortunately. Anyway, for our perspective, we should know what is uniform civil code, we should know what is going to be the implication of uniform civil code, we should know what are the provisions in the constitution related to the uniform civil code, which is article 44 of the Indian constitution, which is not enforceable on its own. For this a provision would have to be made by the state, na, to state can endeavor to, wo kehta hai, but it is, as I said, not so such an easy thing to carry on with. Anyway, so that is what we need to understand as far as the uniform civil code is concerned. अच्छा, अब इस पे आ जाते हैं hate speech पे. Hate speech, sedition, both of these topics we will deal with them together. Both of these are related to article 19 of the Indian constitution. So article 19(1)(a), what right does it give, है ना, right to freedom of speech and expression. Is this right available to all the citizens of India, or is it available to citizens and non-citizens? Only citizens, है ना. So one is article 19 के अंदर जो भी सारे rights हैं, they are only available to the citizens. Now tell me something, is the right to freedom of speech and expression given under 19(1)(a) absolute in nature? No, it is not absolute, है ना. So this right is not absolute in nature, right? Now what are the grounds on the basis of which restrictions can be imposed on article 19(1)(a)? ये कहां पे लिखे हैं, right? So article 19 clause 2 provides the grounds on the basis of which freedom of speech and expression under article 19(1)(a) can be reasonably restricted by the state. So article 19(2) gives powers to the state to impose reasonable restrictions on the exercise of 19(1)(a) और उसके लिए कुछ ग्राउंड्स मेंशन है स्पेसिफिक, वो ग्राउंड्स पता होने चाहिए हमें. व्हाट आर दोज ग्राउंड्स? क्या क्या ग्राउंड्स हैं? फर्स्ट इज सॉवरेनिटी एंड इंटेग्रिटी ऑफ इंडिया, और बताइए. सिक्योरिटी ऑफ, है ना, सिक्योरिटी ऑफ द स्टेट, पब्लिक ऑर्डर, फ्रेंडली रिलेशंस विद फॉरेन स्टेट, है ना, फ्रेंडली रिलेशन विद फॉरेन स्टेट्स. वेरी गुड. देन मोरालिटी, डिफेमेशन, कंटेम्प्ट ऑफ कोर्ट, और क्या है? यस. एंड इंसाइटमेंट टू एन ऑफेंस. क्या सेडिशन मेंशन है इसमें ग्राउंड? नो. सो grounds which have been mentioned in Article 19(2), on the basis of which freedom of speech and expression can be restricted by the state in a reasonable manner, include sovereignty and integrity of India. It should not affect the integrity of the nation. It should not affect the sovereignty of India as a country. It should not affect security of the state. You should not be passing on the secrets of India to some enemy nation simply because it is a freedom of speech and expression to speak or express. It should not affect public order. So basically that should be public tranquility, public peace that should be maintained. इससे disruption नहीं होना चाहिए public order में. It should not affect friendly relation with foreign state. It should not affect morality. It should not affect, or it should not lead to contempt of court. It should not lead to defamation. And another ground can be incitement to an offense. Now understand one thing. Sedition is not mentioned as a ground for restricting freedom of speech and expression under Article 19(2) of the Constitution. But Supreme Court of India has stated that Section 124(a) of Indian Penal Code, इसमें क्या लिखा है? सेडिशन के बारे में लिखा है. कैसे डिफाइन करता है सेडिशन को? इट सेज दैट whosoever by words, either written or spoken, or by visible representation, signs, symbols, etc., tries to bring disaffection or tries to cause disloyalty towards the state established by law in India, then such a person would be charged with the crime of sedition. अब ये जो सेक्शन 124(a) है, पहले तो आपको इसकी हिस्ट्री थोड़ी बहुत समझनी चाहिए. This was not originally there in the Indian Penal Code. This was added in 1870. Gandhi was arrested thrice under this law. And Tilak was arrested under this law. Gandhi, after the non-cooperation movement, for writing an article in Young India, was arrested under this law and was put behind the bars. Gandhi said about Section 124(a) Indian Penal Code in Young India magazine that this is the prince amongst the most unjust laws that have been made by the British. है ना? इसीलिए उसको जेल में डाल दिया. अब आप सोचिएगा कि यही सेम लॉ जिसके खिलाफ गांधी लड़ रहा है एंड what he was struggling for against the British, वही सेम लॉ हमने रिटेन कर ली आफ्टर इंडिपेंडेंस ऑल्सो. नाउ कॉन्स्टिट्यूशनैलिटी ऑफ दिस लॉ वाज चैलेंज्ड इन द कोर्ट. देखिए, लॉ कह रही है कि if your words, if your speech brings disaffection towards the state government established by law in India. अब ये तो बड़ी अजीब सी बात है. In a democracy, if you cannot criticize the government, then what is the point of democracy? One is that. Second thing is, तो ये तो colonial law है. This was in order to keep a check on the Indians from speaking against the British government in India. It makes no sense to retain in India after independence. है ना? It is a relic of the past. It's a colonial law made for a colonial purpose. It does not have any place in 21st century democracy. One thing which we need to understand is that. Secondly, गांधी खुद कह रहा है कोर्ट के अंदर कि सर Are you saying that you will manufacture my affection towards the government? I don't have affection towards the government. Do whatever you want to. I will show disaffection and I will also tell others to have disaffection towards the government. If in a country a citizen cannot have disaffection towards the government, then what is the point of democracy? So section 124A को पहले तो उसकी हिस्ट्री ये है. अब section 124A was challenged in the Supreme Court in a case called as Kedarnath versus State of Bihar in 1963. In this case, the Supreme Court of India upheld the constitutional validity of section 124A. But कोर्ट से ये बोला गया कि सर सेडिशन तो ग्राउंड ही मेंशन नहीं है फॉर रिस्ट्रिक्टिंग फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, एंड दिस सेडिशन लॉ इज रिस्ट्रिक्टिंग फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. सो आप किस ग्राउंड पे कह रहे हैं? तो कोर्ट सेज दैट सेडिशन कैन बी अपहेल्ड ऑन द ग्राउंड्स ऑफ पब्लिक ऑर्डर or on the grounds of security of the state or on the grounds of the incitement to an offense. So basically, or sovereignty and integrity of India. So the court says that only if your speech, if your words, written or spoken, or your gestures or symbols incite violence, then only it would be considered as a seditious act. Otherwise, there is no sedition. But government कहां सुनने वाली है? Government has been charging people left, right and center for sedition. तो इसके खिलाफ PIL फाइल किया गया है ना. PIL was filed last year in the court कि सर ये लॉ को अनकॉन्स्टिट्यूशनल डिक्लेयर कीजिए, लोगों को उल्टा सीधा चार्ज किया जा रहा है. आपने बोला था दैट दिस लॉ शुड बी यूज्ड ओनली इन वेरी specific circumstances. Only in these cases this law should be invoked. Should be invoked only when violence is incited or when it results in violence. केवल उसी केस में सेक्शन 124A चार्ज होना चाहिए, सेडिशन लगना चाहिए किसी के ऊपर. आपने ये बोला था, पर गवर्नमेंट को देखिए किसी भी केस में सेडिशन लगाते जा रहे हैं लोगों के ऊपर उल्टा सीधा, स्टेट्स भी सेंटर भी. सो देन एट दिस क्रूशियल जंक्चर सुप्रीम कोर्ट ऑफ इंडिया आज दी सेंट्रल गवर्नमेंट क्या कर रहे हो बताओ. सेंट्रल गवर्नमेंट गेव एन एफिडेविट to the Supreme Court stating that the Prime Minister is personally very deeply pained. It is Azadi Ka Amrit Mahotsav and 75th year of celebration of independence and blah blah blah, and he's very deeply pained that we are carrying out a law, we are using the same law which was a colonial law made by the British. तो फिर हटा दीजिए. फिर इन्होंने गवर्नमेंट ने बोला कि आप हमें टाइम दीजिए, हम कुछ करेंगे. अब देखिए टाइम इन्होंने मांगा था जून में पिछली साल ना, जून 2022 is when the court gave its judgment. कोर्ट ने बोला हम इस लॉ को अबेयंस में रख रहे हैं. अबेयंस क्या होता है भगवान ही जानता है. अबेयंस बेसिकली मींस वन, as much as I can understand that there. अब कोर्ट ने ना बड़ी अजीब सी एम्बिग्यूअस सी जजमेंट दी है. उन्होंने बोला है दैट द स्टेट्स और द पुलिस एजेंसी शुड रिफ्रेन फ्रॉम यूजिंग दिस लॉ. इफ दे विल रिफ्रेन, भाई अगर घोड़ा घास से दोस्ती करेगा तो खाएगा क्या? अगर आप उस लॉ को मिसयूज नहीं करेंगे पुलिस वाले, तो फिर कैसे वो अपना पावर परपेचुएट करेंगे, हरास करेंगे या पैसे कमाएंगे? हाउ विल दे डू दैट? या पॉलिटिकल ऑपोजिशन को कैसे परेशान करेगी कोई भी स्टेट गवर्नमेंट या कोई भी गवर्नमेंट? सो दिस जजमेंट ऑफ द कोर्ट इटसेल्फ वाज माइंड बॉगलिंग. अब उसके बाद से देखिए आज 17 फरवरी हो चुकी है ना. सिंस देन almost 8 months have passed, nothing has been done. Apparently government was very deeply concerned about this law, है ना. So you can see how much deeply concerned they are. 8 months have passed, they have not done anything. उसके बाद से 3 सेशन हो चुके हैं पार्लियामेंट के, मॉनसून, विंटर, बजट. तीनों सेशन में अभी तक तो कोई ऐसा दूर दूर तक उम्मीद नहीं दिख रही है कि सेक्शन 124A को रिपील करने के लिए या रिफॉर्म करने के लिए कुछ लॉ लाया जा रहा हो. एटलीस्ट नथिंग विच इज नोन टू मी. एनीवे, the point is that this is section 124A of the Indian Penal Code, है ना. And the court says that there, even though sedition is not mentioned as a ground for restricting freedom of speech and expression, but no such speech or act which simply criticizes the government should be called as seditious. Only if it incites violence, only if it is to affect sovereignty and integrity of India, would it be called as a seditious act, and only then people should be charged with sedition. And in the recent judgment, court has stated that as much as possible, states, police agencies, etc. should refrain from charging people under this particular law. जो ongoing cases हैं उनको भी जो है abeyance के अंदर रख दिया जाए, and they should also be kept aside for the time, is what the court has stated as far as the sedition law is concerned. Is that clear to everyone? Now, another thing related to this is hate speech. So what is hate speech? When you make speech, remarks against any particular community with the objective of either causing hurt to religious sentiments, or with the perspective of trying to promote enmity between two groups or communities, that is what is called as hate speech. Now, is hate speech covered under 19(1)(a)? Of course not. Why? Because speech under 19(1)(a) is not absolute. It can be restricted on the grounds of public order and incitement to an offense. तो अगर आपकी स्पीच से पब्लिक ऑर्डर अफेक्ट होगा, then you are not allowed to carry out speech. Freedom of speech and expression can be restricted on the grounds of public order or incitement to an offense. That is why there are some provisions in the Indian Penal Code which punish the act of hate speech. There are some provisions in IPC which punish the act of hate speech. अब वो provisions पता होने चाहिए हमें, because this entire hate speech has been in news this year. So if we look at the provisions, Indian Penal Code, one is section 153A and another important section is 295B. दो sections बहुत important हैं ना. One is not 295B, sorry, 153A and 295A. These are the two sections which are important under the Indian Penal Code, according to which any speech that either tries to hurt religious sentiments or feelings of the others, or speech that tries to promote enmity between two group of citizens, would be chargeable as an offense under these two provisions. What is the constitutional basis? 19(2). इन दो प्रोविजंस का कॉन्स्टिट्यूशनल बेसिस क्या है? कोई ये भी तो कह सकता है सर दिस इज अगेंस्ट फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, ये भी तो कह सकता है ना. But it is not against freedom of speech and expression. Why? Because freedom of speech and expression itself is not absolute in nature and can be restricted on the basis of the grounds that have been mentioned in 19(2), which include public order and incitement to an offense, or sovereignty and integrity of India, or security of the state. So those things have to be kept in mind by you. Hate speech, sedition related provisions broadly पता होना चाहिए. Important thing to remember here for the prelims exam is 19(1)(a) and 19(2). So revise 19(1)(a). Go and see 19(2). जो भी आपने पढ़ा है, जो भी आपने समझा है 19(1)(a) और 19(2) से related, जाके एक बार पढ़ लीजिएगा. Is that clear to everyone? Right? So this is about. अच्छा, by the way, the handout which I was talking about. See, what I have done in the handout is I have just put some very basic revision notes, है ना? Sorry. I have just put some basic revision notes for today's class. Again, for tomorrow's class and for the class on Monday and Tuesday also, I will do the same, so that you people have something to go back to in case you want to revise. And so 16 related kuch provisions ki basic explanation I have provided it. This is nothing but this is primarily the class notes that I give when I conduct the regular batches year revision. Also, similarly, Uniform Civil Code, etc. related, what is Uniform Civil Code? Then similarly, sedition related, what was the judgment of the court in Kedarnath case, what was the judgment of the court in Sanskar Marathe case, that also I have mentioned there. Okay? So this is about hate speech, freedom of speech, this is about sedition. Now let's move on to the next topic. आगे चलें. Any questions till here? क्या डिसेंट? डिसेंट, हाँ, क्या बताऊं उसमें? किस में? 19 में डिसेंट? डिसेंट, डिसेंट कह रहे हो? डिसेंट, अच्छा, हाँ, क्या बताऊं डिसेंट के बारे में? सर आपके सामने मैंने ग्राउंड्स बताए आपको. मैंने आपको ये भी तो बोला सर कि mere criticism of the government does not amount to sedition. कोर्ट कह तो रही है ये बात. ठीक है. Now, let's talk about preventive detention related provisions. So, as far as preventive detention is concerned, first you should know there are two types of detention. दो तरीके से अरेस्ट हो सकता है आदमी का. One is punitive, है ना. So there are two kinds of detention or two kind of arrests that can be made. One what is called as punitive detention, and the other one is called as preventive detention. Punitive detention is basically when either you have been convicted of a crime or whether when you are accused of a crime. When you are either accused or you are convicted of committing a crime, then you are given punitive detention. आपको जेल में रखा जाता है. That is what is called as punitive detention. And so either on accusation, so either an accused or a convict would be detained under punitive detention provisions. There are certain safeguards that have been given in the Indian Constitution in case you have been arrested or detained in punitive detention cases. जब आपके ऊपर कोई एलिगेशन है या आप कन्विक्ट हो चुके हैं तो आपके पास कुछ प्रोटेक्शंस हैं. Which article of the Constitution give these protections? Article 22. What are the protections given in 22(1) and 22(2)? What are the protections? क्या protections हैं? Right. So any person who has been arrested should be informed as soon as possible of the grounds of arrest. Secondly, every person who is arrested should have the right to consult legal practitioner of his choice or to be defended by legal practitioner of his choice. और तीसरा क्या है? Should be presented in front of the nearest magistrate within 24 hours of arrest, excluding the time of, है ना, from the place of arrest to the nearest magistrate. So there are three protections which have been given under this. One protection is grounds of arrest must be informed to the person as soon as possible. Second protection is that should have the right to get a legal practitioner of his choice, consult him or to be defended by him. And third is to be presented within 24 hours in front of the nearest magistrate. है ना, नियरेस्ट मैजिस्ट्रेट के सामने 24 घंटे के अंदर प्रोड्यूस करना जरूरी है. ये तीन प्रोटेक्शंस अवेलेबल हैं. हाँ, ऑफ कोर्स, मतलब 24 आवर्स तक डिटेंशन होता है और उसके बाद if the further detention is not approved, either police or judicial custody, then in that case the person would have to be released, है ना. Now the other thing which we need to keep in mind is that these protections under 22(1) and 22(2) are not applicable to whom? हाँ, ये किसको नहीं अवेलेबल है? It is not available to enemy aliens. And who else? और क्या लिखा है? 22(3) में लिखा है कुछ. हाँ जी. Yes. So these protections are not applicable to enemy aliens, basically citizens of those countries whom India is at war with. And secondly, and in case of preventive detention, ये preventive detention के केस में protections available नहीं है. Is that clear? So these protections are not available in case of preventive detention and these are not available to enemy aliens. This is what we need to keep in mind about punitive detention. Now is preventive detention. अब preventive detention क्या होता है? Preventive detention is You would be arrested on the grounds of apprehension that you may be a threat to public order. You may be arrested on the grounds of a suspect that you may commit a crime. तो आपने कुछ किया नहीं है, पुलिस आपके घर पे आएगी, बोलेगी चलो, आप बोलोगे क्यों, वो बोलेंगे बाद में बताएंगे, बोलेंगे आपने मैंने क्या किया है, तो बोलेंगे तुम करने वाले हो, इसलिए लेके जा रहे हैं तुम्हें। ठीक है, प्रिवेंटिव डिटेंशन। अब देखिए दुनिया में बहुत कम डेमोक्रेटिक कंट्रीज हैं जिन्होंने अपने कॉन्स्टिट्यूशन में प्रोविजंस रखे हो प्रिवेंटिव डिटेंशन से रिलेटेड। व्हेन सरदार पटेल डिबेटेड द प्रिवेंटिव डिटेंशन एक्ट 1950 इन दी पार्लियामेंट, जिसके अंडर ए के गोपालन को अरेस्ट किया गया था, ए के गोपालन वर्सेस स्टेट ऑफ मद्रास, है ना। सो व्हेन ही डिबेटेड अबाउट दिस इन दी पार्लियामेंट ऑफ इंडिया, ही स्टेटेड कि मैं 2 रातों से सोया नहीं हूं because of the inclusion of these provisions into the Indian Constitution and in the Indian law. ये हम ऐसी लॉ रख रहे हैं, मेरे को खुद को चैन नहीं आ रहा है, because these were the same laws that we fought against the British for. इसी के लिए तो, इसी के खिलाफ तो हम लड़े थे ब्रिटिश से, and today we are ourselves including this in our constitution. So I am therefore myself at unease with the provisions related to preventive detention. But what do? My hands are tied. There are communal tensions in the country. A lot of elements within the country are trying to break up the country into parts, and before they do something which can be very disastrous for the nation, we have to stop them. That is why we need preventive detention provisions. But there are certain safeguards that have been provided in the Indian Constitution for preventive detention as well. So let us talk about those. So preventive detention समझते हैं. Preventive detention is a situation in which a person is arrested on the suspect that he may cause a threat to public order or something like that, or to integrity of the nation, etc. and all of that. That person may carry out some crime, may be a threat to public order, etc. तो उस केस में उस आदमी को अरेस्ट कर लिया जाता है. अच्छा, टेल मी समथिंग बिफोर आई मूव फॉरवर्ड एंड डिस्कस अबाउट द safeguards related to preventive detention. Who has powers to make laws on preventive detention in India? Huh? Only, how many of you think it's only Parliament which has the powers to make laws on preventive detention? 1, 2, 3, 4, 5. Okay, how many of you think only the state legislature have the powers to make laws on preventive detention? 1. How many of you think both state and parliament, both parliament and the state legislature have powers to make laws on preventive detention aspects? Because there are entries that have been given in the union list as well as in the concurrent list on the basis of which preventive detention laws can be made. अब आपके पास बेयर एक्ट तो होगा नहीं, बट अगर मैं आपको बताऊं एंट्रीज इन शेड्यूल 7. सो लिस्ट 1 समझते हैं सब लोग, यूनियन लिस्ट 1 में एंट्री 9, preventive detention for reasons connected with defense, foreign affairs or the security of India, person subject to such detention. So point is that entry 9 of list 1, ये किसको पावर दे रहा है? Parliament to make laws with respect to preventive detention. And then if you look at list 3, entry 2 होना चाहिए उसमें, नहीं, entry 3 in list 3, preventive detention for reasons connected with security of the state, maintenance of public order, or maintenance of supplies and services essential to community, person subjected to such detention. So entry 3 of list 3. List 3 किस किस को पावर देती है to make laws? Both state and parliament. So both state and parliament can make laws related to preventive detention. We have a number of existing preventive detention laws in India. UAPA, NDPS, National Security Act 1980. These are some of the laws. Earlier we used to have MISA, Maintenance of Internal Security Act, TOTA, TADA. All of these are laws which are providing for preventive detention. कुछ states की भी law है. Gujarat Control of Terrorism and Organized Crime Act. Maharashtra Control of Organized Crime Activities. Karnataka Control of Organized Crime Activities. All of these have preventive detention provisions. है ना? So powers to make laws with respect to preventive detention are given to both state legislature as well as to the parliament, as per concurrent list as well as union list also. Now, what are the safeguards? Let us talk about safeguards. See, कोर्ट का ऐसा कहना है कि preventive detention has been misused by the government in India, and we need to be very careful. People should not be just charged with preventive detention left, right, and center, because it curbs their liberty and therefore has a severe impact on Article 21 of the Indian Constitution. है ना? Article 21 and also Article 19, 19(1)(d), 19(1)(e), है ना? All of those are also affected as a result of preventive detention. So therefore the court says that preventive detention should be made in very limited cases. But government को देखिए आप, लेफ्ट राइट सेंटर जिसको भी अरेस्ट किया जा रहा है प्रिवेंटिव डिटेंशन में, सालों सालों जेल में रखा जाता है. Also, the big problem with preventive detention provisions is what we are going to look at now. Now, what are the safeguards which are there? Safeguards are that first and foremost, every person who has been arrested under preventive detention must be informed of grounds of arrest, as well as should be given a reasonable opportunity to defend or to contest the arrest. Principle of natural justice, right? Every person who is accused in a case should be given an opportunity to give his view, should have right to a fair hearing. So preventive detention के अंदर provision एक तो ये है that must be informed of grounds of arrest as soon as possible, and reasonable opportunity must be given to prevent must be given to the individual to defend his detention as well. But there is an exception to this. So if I show you Article 22(5) and 22(6), see 22(5) reads, 22(5) is the first provision, which is giving protection in case of preventive detention. 22(5) says that when a person is detained in pursuance of an order made under any law providing for preventive detention, basically when a person is arrested under a preventive detention law, the authority making the order shall, as soon as may be, whichever is the authority which has made the order for preventive detention, shall, as soon as may be, communicate to such person grounds on which such order has been made, and shall afford him the earliest opportunity of making a representation against the order. But there is an exception to this in 22(6), which is, अगर उस authority को लगता है that disclosure of any facts would be against public interest, then they may even deny giving information to that individual who has been arrested under preventive detention provisions. So 22(6) says that nothing in clause 5 shall require the authority making such an order, as is referred to in that clause, to disclose facts which such authority considers to be against public interest to disclose. So 22(6) is an exception to this principle. An exception to this principle has been given in 22. ये क्या कह रहा है? That the arrested person may be denied to know the facts that may be against also. No arrest which has been made under preventive detention law can be for more than 3 months unless it is approved by the advisory board made by the Parliament of India and by the government. So basically, अगर 3 महीने से ज्यादा का अरेस्ट है, so the second safeguard is no arrest more than 3 months unless approved by advisory board to be formed by the government. अब इस advisory board की क्या composition होगी? हाँ, हाई कोर्ट के जज होंगे. What? Who will be the members of advisory board? Yes, people those who are qualified to be judges of high court, or people those who are judge of high court or who have been judge of high court. These will be the people who will be members of this advisory board, which would recommend if a person should be detained for a period of more than 3 months. Maximum period of detention क्या होगा इसमें, वो कैसे डिटरमिन होगा? यस, सो मैक्सिमम पीरियड ऑफ डिटेंशन 3 महीने का तो डिटेंशन देखिए ऑटोमेटिकली हो सकता है. उसके बियॉन्ड अप्रूव करना है तो एडवाइजरी बोर्ड विल गिव द अप्रूवल. मैक्सिमम पीरियड ऑफ डिटेंशन shall be decided by parliamentary law. अच्छा, इसमें एक और चीज है. पार्लियामेंट may also suggest that in certain kind of cases, class of cases, certain category of cases, the approval of the advisory board may not be required for detention beyond 3 months period. So the point which you need to keep in mind is that exception है इसका, इस वाले principle का, that parliament may provide a category of cases. See, basically parliament can mention that terrorism related cases में detention can be made even without the approval of the advisory board. So parliament may provide a category of, sorry, cases होगा, classes नहीं, a category of cases. अरे भाई कैटेगरी लिख दिया ना, क्लासेस कैटेगरी एक ही तो बात है. सो कैटेगरी ऑफ केसेस इन विच डिटेंशन कैन बी बियॉन्ड 3 months without the approval of advisory board. This is another exception to the protection which has been given under this particular law, which we need to keep in mind. Is this clear to everyone? Right, so I have also provided a summary of these particular provisions in the handout that I have shared with you. So if you see, I provided here an advisory board would be a quasi-judicial body that would consist of members who are or have been or are qualified to be appointed as judges of high court. The members of the board are supposed to be appointed by the executive and their functioning is regulated as per a law made by the parliament. वो क्या inquiry करेंगे and all of that will be decided by the law made by the parliament. If parliament by law has provided circumstances or class of cases in which detention can be made beyond a period of 3 months without the approval of the advisory board, then the detention would be legal beyond the period of 3 months as well. A person cannot be detained beyond the maximum period provided by the law of the parliament. And 22.5 and 22.6 I have already discussed with you. So this is about the preventive detention provisions under the constitution. Yes, sir. They'll have to change the constitution. मैक्सिमम 3 महीने का तो है ही सर, मिनिमम 3 महीने तो है ही, वो उसके लिए एडवाइजरी बोर्ड की रिक्वायरमेंट नहीं है. क्या 3 महीने से कम? मैक्सिमम पीरियड ऑफ डिटेंशन ना, बियॉन्ड भाई 3 महीना तो वैसा ही है सर. सर 3 महीने तो आप किसी भी प्रिवेंटिव डिटेंशन लॉ में आदमी को अरेस्ट कर ही सकते हैं. 3 महीने के बियॉन्ड एडवाइजरी बोर्ड की रिक्वायरमेंट है, और 3 महीने से आगे कहां तक जाएगा मैक्सिमम पीरियड, वो मैक्सिमम पीरियड इज टू बी डिसाइडेड बाय पार्लियामेंट. समझ रहे हैं आप? दैट इज व्हाट मैक्सिमम पीरियड इज, नॉट द 3 months. हाँ बोलो. हाउ? सेम ही है सर. प्रिवेंटिव डिटेंशन इज यूजुअली डन इन फॉर्म ऑफ हाउस अरेस्ट यूजुअली. सी यू हैव टू अंडरस्टैंड वन थिंग. प्रिवेंटिव डिटेंशन का ऑर्डर कौन देता है? एसपी देता है. हाँ, कौन देता है? पुलिस करती है प्रिवेंटिव डिटेंशन? हाँ, पुलिस करती है क्या प्रिवेंटिव डिटेंशन? कौन करता है? अरे डीसी देता है ऑर्डर, डीएम देता है, डीएम के पास है पावर्स प्रिवेंटिव डिटेंशन ऑर्डर देने की। जब आप लोग आईएएस में जाएंगे, आप लोग ऑर्डर देंगे प्रिवेंटिव डिटेंशन का, पुलिस नहीं करती कुछ। पुलिस तो सर प्यूनिटिव डिटेंशन करेगी अंडर दी इंडियन पीनल कोड एंड सीआरपीसी, राइट। प्रिवेंटिव डिटेंशन इज मेड बाय द सिविलियन अथॉरिटीज। तो डीएम के पास पावर होती है, डीएम एसडीएम हैव द पावर्स टू मेक प्रिवेंटिव डिटेंशन, प्लीज अंडरस्टैंड दैट। ठीक है, इज दैट क्लियर? सो this is about the preventive detention and the safeguards that have been provided in the constitution related to preventive detention. yahan tak clear hai, right? So I'll just quickly take you through whatever material is there. abhi tak yahan tak ka dekh lete hain, then we'll go into a break and after the break we'll resume. So this all we have discussed. We have discussed about preventive detention also. Acha, ab UAPA, Unlawful Activities Prevention Act. This was a law that was enacted in the year 1967. And this was to prevent unlawful activities, especially those activities that may have an effect on the sovereignty and integrity of India. Under this law, the government can not only declare individual organizations to be banned organizations, but also it can also punish individuals as well, or can charge individuals also under the UAPA. In 2019, there were certain changes that were made to this particular law, which you should be knowing about, because there is already a mains question which has been asked in 2019 related to that. 19 में already एक question आ चुका है, changes which were made in the NIA Act and the UAPA Act of 67. The changes that were made was that now even in पहले क्या था कि organizations could be declared as unlawful organizations and terror organizations under UAPA, but now even individuals can be declared as terrorists under UAPA. अब ये बड़ी draconian law है. Reason is because it is non-bailable, है ना, it's a non-bailable law. तो आपको non-bailable का मतलब ये है कि आपको bail automatically नहीं मिलेगी. It would only be given if the magistrate approves, and the burden of proof would be on you. That is the problem. और बहुत सारे आपने आर्टिकल्स वगैरह भी न्यूज़पेपर में पढ़े होंगे that there are lot of issues associated with the way the UAPA has been misused by the governments in the past. Anyway, the point which we need to keep in mind is that what is this UAPA? It defines unlawful activity as an action taken by an individual or a group of people, association, that leads to secession of a part of India from India, or it results in affecting sovereignty and integrity of India in some or the other ways. So the powers, कुछ ये important चीजें prelims के लिए क्या हमें ध्यान रखनी है. Cases under UAPA are supposed to be investigated by both the state police as well as by the National Investigation Agency, because NIA is the counter terrorist investigation agency that we have in India. Any terrorist related cases, terrorism related cases, investigation is supposed to be carried out by the NIA along with the state police. So UAPA gives powers to central government to impose all India bans on various groups, associations, etc. As you would know that a number of organizations such as SIMI, the Student Islamic Movement of India, the Jamaat-e-Islami, and a large number of CPI, Maoist, etc. बहुत सारी ऐसी organizations हैं which have been declared as illegal, banned organizations under the provisions of UAPA 1967. Then there is a tribunal which has also been created under this law. So in case if there is a ban which has been imposed on you, you can challenge your ban in front of this particular tribunal. Also, both the Indian and foreign nationals can be charged under this particular law. There were certain changes which were made in the 2019 Act. You please go through it on your own. Already a mains question has been asked related to this. So I won't be very surprised if they ask a prelims question also on this. Chances are less, but still for your own sake, please read it. Then one more topic which we'll just quickly cover, phone tapping. So recently this has also been in news. Now see, phone tapping is nothing but an exercise or an activity in which the phone conversations of an individual or individuals are recorded or tapped into by the security agencies. In India, phone tapping is a serious risk 1 to 19(1)(a), freedom of speech and expression. Why? Because if you know Shreya Singhal case, In that, the Supreme Court of India stated that freedom of speech and expression does not extend only to words written and spoken, but also includes communication over modern means of communication, expression over modern means of communication, such as internet, WhatsApp, टेलीफोन. ये सब भी आपके फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन में ही इंक्लूडेड है 19(1)(a) में. दूसरी बात, if you tap into someone's phone conversations, it results in an invasion of an individual's privacy as well. And the Supreme Court of India has stated that privacy is an intrinsic part of Article 21. Why? Understand this. Article 21 says that no person shall be deprived of life and personal liberty except according to a procedure which has been made by the law. Now, court says that life in Article 21 does not merely mean animal existence. Article 21 में जो life mentioned है उसका मतलब है everything that makes a person's life worth living. Supreme Court in the K.S. Puttaswamy case, right to privacy judgment in 17, stated that, quoting one of the Vedas, that in one's house every man is a king, and it is one's personal right, natural right, not given by the constitution alone, but natural right, that if you do not want some information about you to be known to someone else, then it is well within your rights to do so. But there are exceptions to this. State can invade your privacy, but it has to show first and foremost why it is invading your privacy. It has to show that the reason for invading your privacy is legitimate. लॉफुल होना चाहिए जिस बेसिस पे स्टेट आपकी प्राइवेसी में इन्वेजन कर रही है. अगर आपके घर पे सीसीटीवी लगा दिया है स्टेट ने, स्टेट हैज टू जस्टिफाई दैट व्हाई हैव दे पुट द सीसीटीवी. उससे क्या अचीव हो रहा है? क्या इससे स्टेट अपना कोई लेजिटिमेट पर्पस अचीव कर रही है? व्हाई एम आई सेइंग दिस? इन पुट्टास्वामी केस, आधार जजमेंट, प्राइवेसी जजमेंट, पीपल सेड कि सर दिस आधार दे आर कलेक्टिंग ऑल द बायोमेट्रिक्स. गवर्नमेंट ने मेरे बायोमेट्रिक क्यों, गवर्नमेंट मेरे से बायोमेट्रिक्स क्यों ले रही है मेरे? Why are they scanning my iris? Why are they taking my thumb impression? Why are they taking my all the details? What if they leak it out? What if that affects my privacy? So the government gave the reason that, sir, the use of Aadhaar is to provide welfare services to the citizens. Use of Aadhaar is to provide subsidies, DBTs, and all these kind of benefits to the citizen, which is a legitimate goal of the state. That is why this slight invasion of privacy of an individual is justified. So one is there should be legality, and any invasion of privacy should be done only on the basis of law. So there should be a legitimate purpose and there should be a lawful backing for invasion of privacy. अगर स्टेट आपके फोन कॉल को टैप कर रही है तो उसको पहले तो ये दिखाना पड़ेगा ये लॉ के अकॉर्डिंग किया हमने, एंड सेकेंडली they would have to show that there was a legitimate purpose of the state which is being achieved as a result of that. Third is proportionality. कोर्ट कहती है कि अगर मक्खी को मारना हो, you will not be using a sledgehammer. कुल्हाड़ी से मक्खी को नहीं मारोगे. So court says that if invasion of someone's privacy is happening, then the state should justify that invasion is proportional to the problem which is being addressed. कहीं पे एक 5 लोगों के बीच में लड़ाई झगड़ा हो गया गुजरात में, आपने सब लोगों के इंडिया में फोन कॉल टैप करने शुरू कर दिए. This is disproportionate to the problem which you are trying to solve by invading someone's privacy. है ना? So in India, invasion of privacy through phone tapping has been regulated by the courts so that a person's 19(1)(a) and Article 21 are not adversely affected. Do you get this? Now, the point which we need to keep in mind is that what is the law under which this phone tapping occurs in India? In India, phone tapping occurs on the basis of the Indian Telegraph Act of 1885 and the rules that have been made under this particular law. इंडियन टेलीग्राफ एक्ट. रूल समझते हैं? सबऑर्डिनेट और डेलीगेटेड लेजिस्लेशन. डेलीगेटेड लेजिस्लेशन समझते हैं? Now see what is delegated legislation, because आगे भी एक और topic है. Just understand it. Very simple topic. What is delegated legislation? See, in today's day and time, governance has become very complex, and it is not possible for the parliament or the legislature to detail out everything in the law that they are making. वो सारी चीजें लॉ के अंदर मेंशन नहीं कर सकते. इट इज नॉट पॉसिबल फॉर द लेजिस्लेचर टू डू दैट. सो व्हाट डू दे डू? They leave the details to be filled by the executive. So executive is given power by the legislature that, see, we are making a framework law, we will make the broad provisions, the detailed provisions of the law should be made by you in form of rules or regulations under that particular law, which is called as subordinate or delegated legislation. Why is it called as delegated? Because the legislature has delegated its work to the executive. See, this, it is not executive's work to make laws. Their work is to implement the laws, but it's not possible for the legislature to tell everything in the law itself, because it's not possible. How can they be telling each and every minute detail in the law? So they leave those things to the executive. Executive makes what is called as subordinate or delegated legislation under parent legislation made by the legislature. Rules made under law are nothing but delegated legislation or subordinate legislation. But one thing which you need to keep in mind is subordinate legislation is subordinate to the parent law. Therefore, it cannot suggest or do anything which is contrary to what is mentioned in the parent law. You get my point? If rules made under subordinate legislation by the executive are contrary to the parent law, then the court will strike them down and they would be held as unconstitutional, illegal. Why? Because they have been made beyond the powers that have been given to the executive by the legislature. You get the point? तो आगे आप अगर टॉपिक पढ़ेंगे तो उसमें डेलीगेटेड लेजिस्लेशन का टॉपिक है. दिस इज व्हाट इट इज टॉकिंग अबाउट. इट इज टॉकिंग अबाउट दिस सेम प्रिसाइज थिंग. हाँ जी बोलिए. सर प्राइवेट इंडिविजुअल आपकी टाइपिंग करेगा ना, तो पहली बात तो कैसे करेगा? कैसे करेगा सर? बग लगाएगा ना, तो आईटी एक्ट में ऑफेंस बनेगा. अब एक क्रिमिनल केस बनेगा ना उस पे, तो रिट कहां लेके जाओगे? सीधा क्रिमिनल केस है यार. देखो, तुम्हें ना पहले तो फंडामेंटल राइट का कॉन्सेप्ट समझने की जरूरत है. उसके लिए फंडामेंटल राइट्स ना इंडिविजुअल्स के खिलाफ है ही नहीं. 99%. क्या सर? देखो, मेरे को मत कॉन्स्टिट्यूशन पढ़ाओ, मेरी बात सुनो जो मैं क्या कह रहा हूं आपको. अरे मेरे भाई, मेरी बात तो सुन लो. मुझे मत कॉन्स्टिट्यूशन पढ़ाओ, पहले मेरी बात सुनो. पहले मेरी बात सुनो, है ना. फंडामेंटल राइट्स आर नॉट एनफोर्सेबल अगेंस्ट इंडिविजुअल्स इन 99% ऑफ द केस. समझ रहे हैं? फंडामेंटल राइट्स का ऑब्जेक्टिव ही नहीं है सर वो. फंडामेंटल, पहले तो आपको वो समझना जरूरी है. फंडामेंटल राइट्स आर सपोज टू बी एनफोर्स्ड अगेंस्ट द स्टेट लार्जली. दैट इज व्हाट दे आर, right? So if an invasion of someone's privacy is happening due to tapping, first and foremost by an individual, it's a criminal offense. तो फंडामेंटल राइट की तो बात बाद में आती है. क्रिमिनल ऑफेंस हो गया पहले. पहले ऑर्डिनरी लॉ में ही चले जाएंगे आप पुलिस के पास और बोलेंगे कि सर लगाइए इसके ऊपर चार्ज अंडर द आईटी एक्ट फॉर इन्वेडिंग एंड आइडेंटिटी थेफ्ट एंड फॉर हैकिंग एंड फॉर स्टीलिंग माय पर्सनल इंफॉर्मेशन. समझ रहे हैं? तो क्रिमिनल एक्ट बनता है सर. ठीक है. हाँ, किसमें सर? whatever any information that is about you, any information, कोई भी इंफॉर्मेशन है आपके बारे में सर, अगर वो स्टेट गलत तरीके से उसको ट्रैक कर रही है विदाउट एनी लेजिटिमेट पर्पस, विदाउट एनी लॉ और in a disproportionate manner, it is a violation of your fundamental right. But for that you will have to approach the court and you will have to prove it that this is against my fundamental right. ठीक है. दूसरी बात सर, 19(1)(a is for the protection of an individual against the state, not an individual. सर मैं आप देखिए ना, मेरी बात सुनिएगा. कोर्ट में से दैट आप इंडिविजुअल के खिलाफ जा सकते हो, है ना, बट द पॉइंट इज आप कहां जाएंगे? यू विल गो टू द कोर्ट. स्टेट के खिलाफ तो सुनने को कोर्ट तैयार नहीं है, इंडिविजुअल के खिलाफ सुनेगी बैठ के. ऐसे तो सर इंडिया के अंदर ऑलरेडी 4.7 करोड़ केसेस आर पेंडिंग. देखिए बोलने की बात अलग है ना, वो मैं समझ गया सर, आई अंडरस्टैंड दैट, बट यू हैव टू ऑल्सो अंडरस्टैंड द प्रैक्टिकलिटी ऑफ इट. It does not make any difference whether they say it is available against individual or state. वो तो of course है, but the reality is that largely the objective is to prevent the misuse by the state only. है ना? हाँ, है ना? हाँ, हाँ सर मुझे पता है ये बात. सर मैंने जैसे आपको बोला कि अगर आपको यूपीएससी सवाल देती है ये, तो हाँ आप बिल्कुल इंडिविजुअल टिक कीजिए, बट यू हैव टू अंडरस्टैंड द अंडरलाइंग ऑब्जेक्टिव ऑफ द फंडामेंटल राइट्स, है ना? ठीक है. एनीवे, सो दीज आर some of the things that you may keep in mind. Indian Telegraph Act of 1885, and also how invasion of someone's privacy is a violation of 19(1)(a) also to a certain extent, and more importantly Article 21 of the Indian Constitution, which is part of right to life, है ना. So court says that if you are invading someone's privacy, you are invading someone's life, their right to live fully. And privacy, it has been defined by the court in 2017 Puttaswamy case as informational privacy, which basically means that, see, privacy can mean a lot of things, na. Informational privacy, it means that if you do not want certain information about you to be known to others, that is what is protected under Article 21 of the Indian Constitution as stated by the Supreme Court of India in the Puttaswamy case. Is that clear? So this is about the telephone tapping. एक last topic और cover कर लेते हैं, then we'll go into a break. This is about right to be forgotten. Now first, what is right to be forgotten? Actually, in the GDPR, General Data Protection Regulations of the European Union, there is a provision of right to be forgotten or right to erasure. What is that? If an individual wants that his or her data that is available with any data controlling authority, with any authority which has got access to that person's data, if that person wants the data to be erased from that entity's records, then he may write to that entity and he has right to be forgotten. This is what is given in the European Union law. In India, the Data Protection Bill of 2019, 21 and the revised Data Protection Bill of 2022 all do not offer any of such services or do not offer any such right, which is right to be forgotten. But so अभी तो vacuum है law का, but Supreme Court of India has stated in one of the cases, in fact 2 cases, that if an individual approaches them for erasure of data which is with some data controlling authority or with some agency, then on a case to case basis it may look into it and may direct that authority to erase that individual's data. This is what is called as right to be forgotten, that you want that you should be forgotten by that particular website or that particular intermediary which has your personal private data. So if you read this, it says that the Supreme Court has directed its registry to remove details of a couple from the search engines and the internet. But as of now, there is no law that exists in India to regulate this right to be forgotten. What is right to be forgotten? It includes that where it involves removing information that was publicly known at a certain time and not allowing third parties to access the information anymore. That is what we need to understand by right to be forgotten. Please understand that right to be forgotten has been given in GDPR, and Article 17 of the GDPR, which came into force in 2018. इसके अंदर it permits a data subject, जिसका data है, to request a data controller who has been given that data to delete personal data concerning him or her without undue delay. As far as India is concerned, there is no law that specifically provides for right to be forgotten at this point of time. Supreme Court of India, though, has recognized right to be forgotten broadly, but till the time there is a law in India, it would largely depend upon the discretion of the court whether to allow the right of being forgotten, of getting their data erased by an individual on a case to case basis, है ना. बट तब तक ये कोर्ट के केस टू केस बेसिस और डिस्क्रिप्शन के ऊपर चलेगा जब तक इंडिया के अंदर कोई लॉ एग्जिस्ट नहीं करती है. सो प्लीज अंडरस्टैंड दैट, है ना. सो क्वेश्चंस में बी आस्क्ड अबाउट what is right to be forgotten, whether it is recognized in Indian law or not. Also, please go through the broad provisions of Data Protection Bill of 2022. There have been numerous articles in the newspapers that have come on this. You may refer, for example, the Indian Express explained articles or the Hindu text and context, wo jo unke articles aate hain na, on right to be forgotten, and most importantly on Data Protection Bill of 2022. Uske major provisions dekh lijiyega. Expect a question on that in the prelims examination on the broad provisions of the draft Data Protection Bill of 2022. Please पढ़ लीजिएगा उसको, है ना. So this is what we'll cover till here. We'll go into a break. After the break, we'll cover some of the other topics as well. I have discussed with you about this minority status. And then another thing is what is also important in this. Okay, so we'll start with the remaining topics. After the break, we'll talk about the elections to the President of India, etc. All of those things we'll discuss. But before I go into the break, any questions? Okay, so what is first and foremost a cognizable and a non-cognizable offense? Can anyone tell me what is the difference between cognizable? Yes, sir. That's it. बस यही होता है. जमानत पे कहाँ पहुंच गए कॉग्निजेबल में? अरे कुछ भी मतलब, हाँ सर. So okay, so what she has said, what he has stated, in cognizable offense, see, usually in Indian Penal Code there is a classification that has been made of offenses. One is bailable and non-bailable. Bailable offenses are those in which you have the right to get a bail, है ना. आपको bail मिलेगी ही वाला बात है, unless it is specifically denied by the magistrate. You have a right to get the bail. In non-bailable offenses, which are more serious offenses, you may be given a bail still, but it would depend upon the magistrate concerned whether he wants to give you a bail or not. One तो ये हो गया. Second is cognizable and non-cognizable offenses. Cognizable offenses are those in which if a police officer comes to know that if any offense has been defined as a cognizable offense has occurred, he is duty bound to first and foremost file an FIR. It's not necessary that the information related to that offense must come to the police officer only through a complaint. Even if he comes to know of it himself, it is mandatory for him to file an FIR in case of a cognizable offense. पहला तो ये है, FIR is mandatory in a cognizable offense, है ना. Second thing is, in a cognizable offense, the police officer concerned may go ahead and conduct search, seizure, as well as arrest without a warrant from a magistrate in order to prevent any other further act happening related to that particular offense, so as to carry out investigation related to that offense. So suppose कीजिए आपने बोला जी मेरे घर के ऊपर जो है एक ब्रेक इन हुआ एंड लोग जो है थेफ्ट करके ले गए, रॉबरी हुआ. So it will become a cognizable offense. In that case, first and foremost, the police officer would have to file an FIR. After that, he will conduct his investigation on the basis of FIR. During that investigation, he can even conduct search as well as arrest individuals without a warrant. Warrant की जरूरत नहीं है. Usually, as she said, it happens in case of those which are more serious kind of offenses. There are non-cognizable offenses. नॉन कॉग्निजेबल ऑफेंसेस, आपने जाके बोला सर इसने मेरे को थप्पड़ मार दिया, उन्होंने बोला कि किसी वेपन से मारा, बोलता नहीं सर सिर्फ थप्पड़ मारा, तो ठीक है, क्रिमिनल असॉल्ट का केस है, बट इन दैट केस इट वुड बी ए नॉन कॉग्निजेबल ऑफेंस. अब क्या होगा? Police will first conduct a preliminary inquiry and they will satisfy themselves that whether this has actually occurred or not, and only after that they will file an FIR in the case. FIR is not mandatory in a non-cognizable offense. Secondly, police cannot arrest anyone, they cannot search and conduct any of those things without they have a warrant from the magistrate concerned. उसके बिना वो नहीं कर सकते. These are non-cognizable offense. अब विद इन इंडियन पीनल कोड देयर इज अनदर क्लासिफिकेशन ऑफ ऑफेंसेस. अब देखिए ये ना ओवरलैपिंग है एक दूसरे से, ये मत समझिएगा कि अगर कोई ऑफेंस बेलेबल है तो वो कॉग्निजेबल ही होगा या नॉन कॉग्निज, इट डिपेंड्स. दैट इट्स अ वेन डायग्राम है ना, इट्स अ कॉम्प्लेक्स सिचुएशन which we don't need to get into unless you are studying for law. The third type of categorization is compoundable and non-compoundable cases. Non-compoundable cases are usually serious offenses. Compoundable cases are usually very innocuous kind of offenses. ठीक है, किसी के बीच में लड़ाई झगड़ा हो गया, अब ये कंपाउंडेबल ऑफेंस होगा in which a settlement can be reached between the parties. A compoundable offense is one in which two parties can reach a compromise and there is no need for this particular case to necessarily reach the court or for the court to decide this case. There can be a settlement between the two parties. In non-compoundable case, there is no possibility of a settlement. For example, murder. A murder में क्या settlement होगा? Right? So there is no settlement in case of a murder case. Right? So there are compoundable and non-compoundable cases. There are offenses. There are cognizable and non-cognizable offenses, and there are bailable and non-bailable offenses. There are three different categorizations that have been provided under the Indian Penal Code. Is that clear, ma'am? Yes. What else? और कुछ है? Clear? Right? So we go into a break now. After the break, we'll continue with some of the other topics, whatever we can cover in an hour's time, and then we'll cover remaining topics in the next three classes. Okay, I'll see you in a few minutes. Now, provisions related to elections of the President of India have also become very important this year. Already a question has been asked in the mains examination last year, where they asked to compare the election process of the Indian and the French president. So you can expect a question in the prelims examination as well. Two important provisions of the Indian Constitution which you need to keep in mind for the election of the president: Article 54 and Article 55. Please remember first that if any change has to be made in these two provisions, then the approval of at least half of the state legislatures is also required. This is mentioned in proviso to Article 368 clause 2. है ना, अगर आप 368 clause 2 के अंदर जो condition provided है वो पढ़ेंगे, it says that if there is any change which is supposed to be made to 54 and 55, it has to be also approved by at least half of the state legislatures in India. Now, what is Article 54? Article 54 provides us the composition of Article 54. Article 54 of the Indian Constitution tells us about the electoral college for the President of India. Who all is included in the electoral college? Right. So elected members of Parliament and elected members of state legislative assemblies. State legislature मत बोलिएगा. State legislative assembly. State legislature would mean legislative councils also. So elected members of parliament and elected members of state legislative assembly participate in the election of the President of India. Article 55 tells us about the manner of election of the president. So the manner of election of the president is mentioned in 55. Manner of election of president. मैनर ऑफ इलेक्शन ऑफ प्रेसिडेंट मतलब कि किस तरीके से प्रेसिडेंट का इलेक्शन होगा. इट सेज दैट the president of India should be elected by a system of proportional representation with a single transferable vote. But to be honest, neither it is a proportional representation system nor it is actually a single transferable vote. A lot of constitutional experts prefer to call this system as alternate voting system. Proportional representation system usually exists where there are multi-member constituencies. That is, if there are 100 voters in the constituency and if there are 10 seats, those 10 seats will be divided according to the number of votes that have been secured by XYZ political party. So if X party has got 30 votes out of 100, they will get 30% seats. If Y party has got 40% votes, they will get 40% seats, and so on and so forth out of those 10 seats which are there. But in case of President of India, there is only one seat. So actually this term proportional representation is a misnomer. And the actual term that should have been used by the constitution makers would have been better if they would have mentioned alternate voting system, but they have mentioned proportional representation with a single transferable vote. I hope all of you know what is the process for the election of the President of India. The process is that there is a ballot paper which is given, on which you have to rank the candidates according to your preference. Actually, to be able to secure the elections to the President of India, you need to get more than 50% of the total value of the votes polled in the election. What is the total value of the votes which are polled in the elections to the President of India? क्या है पता है किसी को? 10.98 lakhs to be equally divided between the union and the states, which basically means that 5.49 lakh votes are assigned to the MPs and 5.49 lakh votes are assigned to the states. And that is what is the division. I mean, you don't need to remember these numbers, but I mean, I'm sure that you would have seen the newspapers, etc., and all the discussion that happened in the newspapers last year related to the election of the President of India. Now, what you need to keep in mind here is that the value of the votes is kept equal between union and states overall, so as to maintain a balance between the union and the states. Now, what is the value of vote of an MLA? First, it is important to decide that. So, value of vote of an MLA is nothing. Every MLA from a different state would have a different value for its vote depending upon the population of that state. So, value of vote of an MLA कितना होता है? Total population of the state divided by total number of elected MLAs. Total number of elected MLAs. But देखिए ये नंबर आएगा बहुत बड़ा. So therefore we further subdivide this by no, which is the state which has maximum value for the vote of an MLA? UP. Minimum Sikkim 7. So anyway, so total population divided by total number of elected MLAs further subdivided by 1000. In this you have to remember that the population is decided as per 71 census till the first census after 2026. This is basically to ensure that those states which have been able to control their population are not adversely punished for being able to do so, and also that we do not encourage this behavior on part of the states that they should keep producing more. So as a result of that, we have frozen this population figure on the basis of 71 census till the first census after 2026. I hope this is known to all of you. Then how is the value of vote of an MP decided? See, it's very simple. Value of vote of MPs is equal to total value of votes of all the MLAs. So can I say that value of vote of an individual MP into number of MPs is equal to total value of votes of all MLAs? Is this correct? So can I say that value of vote of an MP would be what? I just remove this and get this here. That would be total number of elected MPs. This way I will get value of vote of a MP also. Value of vote of all the MPs is same. Is Rajya Sabha's MPs vote equal to Lok Sabha MPs vote? Is Uttar Pradesh MPs vote equivalent to Nagaland MPs vote? Is value of vote of an MLA of UP equal to value of vote of a Nagaland MLA? No. Right? Also, is value of vote of an MLA from Noida equivalent to that of value of vote of an MLA from, let's say, Ayodhya? Yes. Within a state, it would be same. But across states, it would vary. But for MPs, it is same. For all the MPs, it is constant. ठीक है. Anyway, so that is what we need to keep in mind. I think value of vote of an MP, if I am not wrong, is 700. शायद ऐसे ही है ना, कुछ भी है, whatever. So that is the process which we need to keep in mind. अब इसके अंदर क्या किया जाता है? रैंकिंग की जाती है. And in the first round of voting, we look at all the first preference votes of all the candidates, those who are contesting the elections. If you happen to get more than 50% of the total value of the votes polled in the first counting itself, you're declared as the winner. If that does not happen, then the candidate with the least number of first preference votes is eliminated from the race. And his second preference votes are transferred to the other candidates. And accordingly, you see that who has been able to get more than 50%. If that also does not happen, then you go into the third preference and so on and so forth. Right? So that is the process which is used for the deciding the election outcomes of the President of India. Now, one thing which you need to keep in mind, in case of president and vice presidential elections, both voting that takes place is through a secret ballot. The process is supposed to be a secret ballot process, which basically means that whom does a person vote for, he does not need to tell anyone else. Which means that anti-defection law does not apply. Which means that you may vote contrary to the whip which has been issued by your political party. So a lot of cross voting happens during the elections of the president and the vice president, as it happened this time also. Which is the body which is supposed to conduct the presidential and the vice presidential elections in India? है ना? देखिए, Election Commission of India has been given the overall responsibility, but the returning officer जो होता है, that is either the Secretary General of Lok Sabha और राज्य सभा alternatively. तो हर बार एक इलेक्शन में लोकसभा को रिस्पॉन्सिबिलिटी दी जाती है सेक्रेटेरियल असिस्टेंस देने की इलेक्शन कमीशन को, एंड वंस द सेकंड टाइम इट विल बी गिवन टू द राज्यसभा. सो द रिटर्निंग ऑफिसर for the elections of the president and the vice president is supposed to be either the Lok Sabha Secretary General or the Rajya Sabha Secretary General. Overall supervision of the elections of the president and the vice president are with the Election Commission of India only. Please remember that. Another thing which you need to keep in mind. Constitution states that if there is a vacancy in the electoral college of the president or the vice president due to any reason, such an election should not be declared as invalid on that particular ground. है ना? Also, which is the court which is competent to entertain election disputes related to the president and vice presidential elections? Supreme Court of India. So if I read Article 71 of the Constitution for you, matters relating to or connected with the election of a president or vice president. All doubts and disputes arising out of or in connection with election of president or vice president shall be inquired into and decided by the Supreme Court, whose decision shall be final. No other court has competence or jurisdiction over such cases. Second, if election of a person as president or vice president is declared void, let's say if the election is declared as void, then it says that acts done by him in the exercise and performance of the powers and the duties of the office of president or vice president, as the case may be, on or before the date of the decision of the Supreme Court shall not be invalidated by the reason of that declaration. So suppose कीजिए person has been elected as president of India और उसके कैंडिडेचर के ऊपर बाद में सवाल उठ गए and a election petition has been filed in the Supreme Court of India challenging his election. In that case, even if the Supreme Court of India declares his election to be invalid, whatever decisions that would have been taken by him till the date of such decision of the Supreme Court should not be invalidated simply because his election was invalidated. You have to understand that also. One, because what has been done. It cannot be changed. And second, anyway, president or vice president are not supposed to be doing anything on their own. And the vice president को वैसे ही कोई role नहीं है. And even president, for that matter, is supposed to be merely carrying out the wishes of the Council of Ministers, and it is supposed to be bound by the aid and the advice of the Council of Ministers. Please keep that particular thing also in mind. Another thing, then if I read 71 clause 3, subject to provisions of this constitution, parliament may by law regulate any matter relating to or connected with the election of a president or vice president. तो इसलिए parliament ने law बना दिया. And election of a president person as a president or vice president shall not be called in question on the grounds of existence of any vacancy for whatsoever reason among the members of the electoral college electing him. So whatever be the case, whether it is an election dispute, whether it is a case related to disqualification, whether it is a case related to some state legislative assembly being dissolved, any reason, it does not matter. The election of the president or the vice president cannot be called into question on the ground of vacancy in their electoral college or vacancy in the electoral college that is supposed to elect them. Is that clear? Right. So this is broadly as far as the election of the president and the vice president is concerned. And in this, in the handout also, I have just provided a brief write-up on the election of the president of India 54, 55, and what is the process that is supposed to be followed, and that the election takes place through a secret ballot in which the anti-defection law does not apply, and therefore a lot of cross-voting happens also in these elections. That is about the election of the president and the vice president of India. So this औरत को कुछ नहीं है इसमें. Right. So that is broadly what we need to keep in mind as far as the election of the president and vice president is concerned. Next topic which we need to cover. So you may just see it here as well. 1 second. See, as you would realize that in prelims exam, ऐसा नहीं है कि कुछ नया पूछ लेगा वो एकदम अलग से, है ना? What will happen is that whatever you've been reading in the newspapers, they will ask the basic of that particular topic. That is how UPSC operates as far as prelims is concerned. Yes, sir. How to, sir, as we are utilizing this, है ना, that we cover the basic topics. As जो मैंने starting में बोला, how we utilize PT365. You use this as a clue to prepare the topic and to revise that entire topic. That's why in today's I know that many of you would have already covered all of this, है ना? ऐसा तो नहीं है कि आपने नहीं कवर किया होगा. बट मैं और क्या पढ़ा सकता हूँ आपको PT365 में? अगर मैं आपको डायमेंशंस पढ़ाना शुरू कर दूं जो कि मेंस रिलेटेड है, it will not make any sense. What we should be doing here is revise whatever has been covered either in whichever coaching institute or even if you have done preparation on your own related to the basics of these particular topics which are been in the news. So that is how questions will be asked. There may be a question on election of president. There may be a question on preventive detention provisions. There may be a question on the right to freedom of speech and expression. There may be a question on provisions related to hate speech. There may be a question. तो उस तरीके के basic questions को tackle करने के लिए हमें conceptual basic understanding होनी चाहिए. Let me tell you, in polity, the good thing is questions are largely very easy to solve. And you can solve 90% of the questions with cent% accuracy. You can check out last year's paper. I think it was one of the toughest papers which has been made in the history of prelims in last 10 to 12 years, at least since I have been observing. And what I can tell you is that in that prelims examination last year, there was only one subject in which you could have been confident of attempting questions with 100% accuracy, and that was only polity. I'm not saying that that would be the case this year as well. God knows what is it going to be this year. Maybe this year they will set very tough questions on polity, but पॉलिटी में बहुत मुश्किल क्वेश्चन सेट करना मुश्किल है, फिर उनको ना फिलोसफिकल क्वेश्चंस में जाना पड़ेगा, जैसा उन्होंने 17 और 18 में एग्जाम सेट किया था। उसमें वो बिल्कुल एकदम एनसीईआरटी के अंदर जाकर बहुत बेसिक चीजें पूछते हैं और स्टूडेंट्स को उस पर क्लैरिटी नहीं होती है, बिकॉज पीपल हैव स्टडीड द कंसेप्ट ऑफ पॉलिटी सुपरफिशियली, है ना, ऊपर से अगर आप पढ़ेंगे तो कभी नहीं समझ में आएगा. दैट इज व्हाई आई ऑलवेज रेकमेंड टू स्टूडेंट्स आल्सो दैट यू शुड रीड एनसीईआरटीज, you should read constitution at work, you should read the political theory ncrt of class 11th, and you should read these basic books, because a lot of questions in prelims are actually framed directly out of ncrts. Unfortunately, students don't refer, and then they think that there are some other sources from which the questions are coming, but the reality is that questions actually come directly from the ncrts only, and that is the truth of the prelims exam which you need to know. Even in subjects such as science and tech, subjects such as environment, a lot of questions are asked directly from the ncrt. Students go for some random texts and coaching institute notes instead of reading the ncrts first properly, because they think ये तो बहुत आसान है. But the reality is exam भी बहुत आसान ही है. Problem is that people tend to make it complicated, because instead of focusing on concepts, you are focused on accumulating knowledge. That is why I always recommend stay away from collecting too much material. Stay away from trying to buy as many notes in the market and then trying to build the pressure on yourself कि ये सब cover करना है. Instead of doing a lot, जितना किया है उसको अच्छे से revise कीजिएगा. That is what we are doing here also. I am not teaching you anything out of the world. ऐसा कोई मैंने आपको एक्स्ट्रा कॉन्सेप्ट नहीं पढ़ा दिया है अभी. समथिंग विच वुड हैव नॉर्मली रेड अर्लियर एज वेल. और प्रीलिम्स के अंदर वैसे ही क्वेश्चन आते हैं. मैं अब इसमें प्रेसिडेंशियल इलेक्शन में आपको ऐसा क्या नया बता दूंगा जो यूपीएस जो आपने पहले नहीं पढ़ा होगा. इट्स वेरी डिफिकल्ट ना. सो यू हैव टू बी गुड विद द बेसिक्स ओनली इज व्हाट यू नीड टू कीप इन माइंड. ठीक है सर. Anyway, now let's come to the next topic. Clemency powers or the pardoning powers of the president and the governor. Now, what are pardoning powers? See, you must know that no judicial system is free from errors. There are always problems in the way the judicial system, criminal justice system work across the world. Indian judicial system more so. I always give this one example to the students in the class that in 2011, a dozen judges of the Supreme Court of India wrote to the President of India that during the 1990s, there were a number of cases in which the Supreme Court of India gave wrong judgment in death penalty. And as a result of that, these people had to lose their lives. Supreme Court wrongly awarded death penalty and applied the rarest of rare doctrine in the various cases in the 1990s. Was a letter that was written by former Supreme Court judges to the President of India in 2011. This itself shows that Indian legal system itself is not free from errors, free from problems. In order to correct any such mistake that may have been made by the court, or possibly you must understand one more thing. A lot of times courts do not take into account the circumstances under which an individual may have conducted an offense or a crime. कोर्ट का काम क्या है? देखिए, कोर्ट का काम है एविडेंस देखना, कोर्ट का काम है विटनेसेस को एग्जामिन करना, क्रॉस एग्जामिन करना, उसके बेसिस और लॉ को पढ़ना और उसके बेसिस पे अपनी जजमेंट देना. बट does not necessarily go into socio-economic conditions of the accused. Let us say, and there has been a case where one person, because he was in so much debt, a farmer, a very poor farmer, because of the failure of the crops, he was in so much debt, he decided that I am going to finish my entire family and myself. So first he killed his own children and his wife with his own hands, and then when he wanted to kill himself, unfortunately his attempt to commit suicide got botched up. He was caught by the police and he was charged with the offense of murder of his children as well as of his wife. But the reality is that he was in such distress that he wanted to kill himself also. Somehow the luck was that he could not. So now in such a case, when the matter goes to the court, court क्या बोलेगी? कोर्ट तो बोलेगी मर्डर का केस है, दीजिए इसको कैपिटल पनिशमेंट या फिर लाइफ इंप्रिजनमेंट. बट देन people are saying that look at the condition of this man. He is already under so much trauma that he also wanted to kill himself. Now you are going to kill him. You are actually going to give him what he wanted. Rather, let him realize what mistake he has made and give him one more opportunity to live. Possibly this is what the God wanted. This is what his destiny needed, that he should survive and he should live through this. Maybe he made the fatal mistake of killing his children and his wife and he wanted to kill himself as well, but this is a second opportunity which life has given him. Let him live with that. So in that case, there is a possibility that one may write a petition to the president or to the governor, asking them to exercise their extraordinary power in order to give some kind of a pardon to an individual who has committed an offense. So this is what is the objective of pardoning powers. This is the philosophy behind pardoning powers given to the president or the governor. Please remember, in the constitution, two provisions of the constitution are important: article 72 and article 161, which give the clemency powers to the president and to the governor. Both these powers are parallel to each other. ये दोनों एक दूसरे के ऊपर नहीं है या कोई किसी के नीचे नहीं है. Both of them are parallel to each other. So in case if there is an offense that has been committed against a union law, then you would have to seek clemency from the president of India. In case an offense has been committed against a state law, you would have to seek clemency from the governor of the state. Now, what kind of pardons or clemency may be given by president or governor? President of India and governor can issue clemency which are in the following nature. One is what is called as commutation. You may change the punishment which has been given to a lighter punishment. So if an individual has been given capital punishment, it may be changed into life imprisonment. Second one is what is called as remission, in which the number of years of punishment is reduced, the term is reduced without changing the character of the punishment, है ना. फिर उसके अलावा तीसरा कौन सा था? Pardon, in which a person is absolved completely of the crime that he has committed, है ना. उसको completely पूरी तरीके से absolve कर दिया जाता है कि तूने कोई crime किया ही नहीं. It is as if that person's criminal record is deleted. Do remember one thing: only president can pardon a death sentence. Governor can commutate a death sentence, but he cannot pardon a death sentence. Pardon का मतलब ये होता है, it is as if आप उस इंसान की जो क्लॉक है उसको उल्टा चला दें, and you will take that person back in time, and not only that person's conviction but also the term or the punishment that has been given to him, both will be removed. That is what is called as pardon, है ना. So the point which we need to keep in mind is that we have these 5 powers, है ना. So I have mentioned about this also here in the handout that I have shared with you, so you may read it from here. Clemency powers: pardon, commutation, remission, reprieve, temporary stay on the execution of a sentence, and respite is temporarily changing the character of the punishment to a lighter one due to certain special circumstances, है ना. So say for example, if there is a person who is of very old age, he says that, sir, I have been given rigorous punishment by the court, rigorous imprisonment, you know, in which you would be made to undergo hard manual labor in the jail, in the prison. So you may ask for your rigorous imprisonment to be changed to simple imprisonment for a short period of time, which is called as respite. Reprieve is there is a temporary stay on the execution of your punishment. For example, let us say that a person has been given death penalty. Now he may approach the governor or the president asking for a reprieve, in which the governor or the president would say that, okay, I am giving you a temporary stay so that you will not be executed, you will not be killed, so that if you want to file appeal in the higher court, you may do so and prepare your arguments and get that time. ऐसा ना हो कि हाई कोर्ट ने आपको डेथ पेनल्टी दी और इतने के अंदर आप जब तक आपने अर्जी लगाई सुप्रीम कोर्ट में आपको एग्जीक्यूट कर दिया गया, तो उस केस में आप रिप्रीव ले सकते हैं. रिस्पाइट इज वेरी सिमिलर टू कम्यूटेशन, बट देयर इज अ डिफरेंस. इन कम्यूटेशन योर punishment is changed to a lighter form for permanent, whereas in respite your punishment is changed to a lighter form for a certain period of time, for a certain duration. Is that clear? Now the other thing which you also need to keep in mind is, तो हमने दो differences समझ ली हैं in the president and the governors pardoning powers. एक मिनट रुक जाइए सर. Presidents and governors pardoning powers. One is that the president can issue pardons only in case of offenses conducted against the union law. Basically, it says that in those cases where the executive power of the union extends, and governor can give pardons in those cases where the offense has been committed against the state law. Second thing is that the governor cannot pardon a death sentence. He may commutate a death sentence. President of India can pardon and commutate a death sentence. दोनों कर सकता है वो. Third thing which you need to understand is that there are some differences in terms of the armed forces tribunal punishment as well. If there is a court martial which has happened against an individual, a punishment has been given by court martial, armed forces tribunal, only the president has powers to exercise clemency powers, not the governor of the state. Also, one more thing. I hope that you have been reading the newspapers and you have read about section 432, 433, 433A, etc. of the CRPC, which have been coming in the newspaper related to the Shabano case. Not the Shabano case. कौन सा था ये? कौन सा? This गुजरात वाला केस क्या था? बिल्किस है ना? Sorry. Yeah. So in that Bilkis Bano case. So in that particular case, you have to remember that one, there is a source of the constitution under 72 and 161 to remit a person's punishment. But there is a source of the ordinary law as well, CRPC as well, under which a person's punishment may be remitted. But not just as per whims and fancies of the state government. एक कॉन्स्टिट्यूशनल सोर्स है 72 161, रेमिशन का एक लीगल ऑर्डिनरी सोर्स भी है विच इज सीआरपीसी. अंडर सीआरपीसी अ पर्सन's punishment may be remitted by the state government or the central government, by the appropriate government, it states the CRPC. But in that you need to understand, if a person has been given a life imprisonment, है ना, तो इन और सपोज कीजिए किसी एक आदमी की डेथ सेंटेंस को कम्यूटेट करके लाइफ इंप्रिजनमेंट में कर दिया गया, उसका रेमिशन नहीं हो सकता जब तक वो 14 साल मिनिमम सर्व ना करे. तो सपोज कीजिएगा देयर वाज अ पर्सन हु वाज गिवन कैपिटल पनिशमेंट, उसकी डेथ पनिशमेंट को आपने कम्यूटेट कर दिया लाइफ इंप्रिजनमेंट में, और फिर अब बाद में वो जाके फिर से रेमिशन की भी पिटिशन फाइल करता है. इन दैट केस रेमिशन कैन बी ओनली डन व्हेन ही हैज सर्व्ड अ मिनिमम ऑफ 14 years in the prison. Only then the remission can be done. उससे पहले उसका remission नहीं हो सकता है. This is another thing which you need to keep in mind. ठीक है, हाँ जी बताइए. Changing the nature to a lighter one in light of certain circumstances. ठीक है. ड्यूरेशन रिमेन्स द सेम बट योर कैरेक्टर ऑफ द पनिशमेंट, रिगरस पनिशमेंट होती है ना सर, जिसमें पत्थर तोड़वाते हैं कैदी से, और एक सिंपल इंप्रिजनमेंट होती है. सो इट विल बी चेंज फ्रॉम रिगरस टू सिंपल फॉर एग्जाम्पल, बट फॉर ओनली अ स्पेसिफिक पीरियड. इट इज सिमिलर टू कम्यूटेशन. ठीक है, कम्यूटेशन इज परमानेंट, रिस्पाइट इज फॉर अ स्पेसिफिक टाइम पीरियड. ठीक है, एनीवे, सो the pardoning powers etc, all of that should be clear to you now. And hanji boliye, and this has also been provided here in the handout that I have shared with you, so you may read more from here. Hanji bolo. Of course it is not a discretionary power of the president or the governor, sir. Of course it is not, hai na. See, first one basic thing you should understand, governor and president are merely titular heads. They are supposed to exercise powers on the aid and the advice of the council of ministers and not on their own discretion. So what you need to keep in mind is that कोई भी देखिए 99% powers of the president and the governor are not their discretion. कोई उसके घर का राज थोड़ी ना है. Also please remember one more thing, in some of the textbooks it is referred, it is mentioned that these are judicial powers of the president and the governor, which to be very honest is wrong. Because this is not a judicial power, this is an exercise of the executive power of the judicial of the executive only. ये executive power में ही आता है. उस executive power को अगर आप क्लासिफाई करना चाहते हैं तो आप उसको judicial nature की power कह सकते हैं, but it is not a judicial power of the president or the governor. Please understand that. मैं ये इसलिए बोल रहा हूं because कुछ text में लिखा होता है it is judicial power of the president or the governor. That is absolutely wrong. Supreme Court in multiple cases has mentioned that this is an executive power of the president or the governor, not their judicial power. उनके पास कोई judicial power नहीं है. Please remember that. Is that clear? about the pardoning powers of the president and the governor, difference between their powers, source of the power, and also please do go and read. Internet पे search कीजिएगा, Indian Express explained, Hindu explained, whatever, on the remission of the convicts in the Shah Bano case, and please read the relevant provisions of CRPC as well, because as I'm telling you, there are two sources of remission. One is Constitution 72 and 161. Another one is the ordinary law, which is under the provisions of CRPC. दोनों के अलग सोर्सेज हैं, दोनों में रेमिशन दिया जा सकता है. ठीक है. जो बिल्किस बानो केस के अंदर रेमिशन दिया गया है, दैट हैज बीन गिवन अंडर प्रोविजंस ऑफ सीआरपीसी, नॉट अंडर द प्रोविजंस ऑफ द कॉन्स्टिट्यूशन. उसमें स्टेट गवर्नमेंट ने remission दिया है ना, after forming a committee which had also obtained the views of the central government and the state government functionaries, and then given this particular opinion that these convicts should be remitted. Is that clear? Now next topic, let's move on to it. अच्छा, लोकपाल एंड लोकायुक्ता, इसके ऊपर what I would suggest is what you should read here is, see all of this is fine, what you should read is this. ये पढ़ लीजिएगा, खुद से पढ़ लीजिएगा, that what is the composition supposed to be of the Lokpal according to the Lokpal Act, then what is supposed to be the tenure of the office, how the members of the Lokpal shall be selected, and what are the powers that the Lokpal would have. तो ये एक बार please table पढ़ लीजिएगा just for your information if a basic question is asked in the prelims examination related to this. Ultimately what you have to remember is Lokpal and Lokayuktas both are agencies which have been created in order to investigate corruption charges against the central and the state government officers. So of course, Lokayukta is under the control of the states. As a result of that, various states have passed their respective laws to create the Lokayuktas in the state. And Lokpal has been set up by the center. है ना? So वो बस एक बार please just go through it. इसमें कुछ अगर आपको बाद में confusion आए, you can let me know tomorrow. But this is very factual, so you may just go through it on your own. Now, other thing is parliamentary committees. Questions have been asked on parliamentary committees in the mains exam. I feel that there is less chances of questions being asked in the prelims on this, but let's still discuss what are parliamentary committees. These are groups which are made of the members of the parliament with the objective of providing assistance to the parliament in its functioning. We know that parliament is too big a group. We know that parliament is too big a body to hold any kind of fruitful discussion. Second is that the parliament in general consists of layman politicians, those who lack expertise in specific areas of administration. By creating a committee, what we can do is that we can create a smaller group of the parliament which can discuss the various issues, legislation, demand of grants behind the doors in the through the parliamentary through the committee stage. Second advantage is that you can recruit or appoint people, those who have expertise in specific areas in these committees. So it's not that you would do away with the layman politician nature of the parliamentary committees, but still there would be some expertise. For example, parliamentary committee on health would maybe have some doctors, those who are part of the parliament. So maybe Dr. Harshvardhan would be a part of parliamentary committee on health. If there is a parliamentary committee on external affairs, possibly the S. Jaishankar and Dr. Shashi Tharoor could be a part of that particular parliamentary committee. So that is how parliamentary committees bring in certain advantage. Also they function round the year, 365 days a year. है ना, उनके ऊपर कोई लिमिटेशन नहीं है कि पार्लियामेंट का सेशन होगा तभी काम करेंगे. पार्लियामेंट्री कमिटीज कैन फंक्शन एनी वे थ्रू आउट द ईयर. Another advantage of parliamentary committees is that parliamentary committees are not, their proceedings are not supposed to be televised or published for the consumption of the public. As a result of that, people tend to be less political in the parliamentary committees and their functioning. They tend to look more at national and public interest rather than trying to express the views of their own political party. तो तू मैं कम होती है parliamentary committees के अंदर in their discussions. Now, what are the types of parliamentary committees? Two types of parliamentary committees are there. Standing committees, ones which are formed for a year or for a longer duration and they carry out their work throughout the year. And then the other ones are ad hoc committees which are formed for a specific purpose, and once they achieve their specific purpose they are dissolved. For example, Joint Parliamentary Committee on the Draft Data Protection Bill. It was formed to analyze the Draft Data Protection Bill, give its suggestions, give its report, and then after it was dissolved. But there are certain committees which are standing committees. You must be knowing about Public Accounts Committee. You must be knowing about estimates committee. You must be knowing about committee on public undertakings. You must also be knowing about the department related standing committees, 24 department related standing committees, each one of which consists of how many members? 31 members, है ना? So you should know about these basic things. कि कितनी डिपार्टमेंट रिलेटेड स्टैंडिंग कमिटीज हैं, व्हाट इज द फंक्शन ऑफ डिपार्टमेंट रिलेटेड स्टैंडिंग कमिटीज, what is the composition of department related standing committees. You must know about composition of public accounts committee. You must know about the functions of the public accounts committee. You must know about the composition of estimates committee. You must also know about joint parliamentary committee. क्यों न्यूज में रहा है, opposition is demanding a JPC. So a joint parliamentary committee is an ad hoc committee that is formed for the purpose of investigation into a specific केस, है ना? तो जेपीसी फॉर्म की जाती है. यूजुअली द चेयरमैन ऑफ द जेपीसी इज फ्रॉम द ऑपोजिशन एंड मिनिस्टर्स आर नॉट सपोज टू बी पार्ट ऑफ द जेपीसी. मिनिस्टर्स को नहीं पार्ट रखा जाता है. सो टू एग्जामिन स्पेसिफिक इश्यूज दैट मे हैव कम इन फ्रंट ऑफ द गवर्नमेंट. तो अभी जेपीसी के ऊपर भी अगर आप देखेंगे, इंडियन एक्सप्रेस एक्सप्लेन के अंदर आर्टिकल आया था that what is JPC, when was the first time the JPC was formed, what are the instances of the formation of the JPC in the past. So see what will happen in the prelims exam is, जरूरी नहीं है वो आपका पूरा क्वेश्चन जो है दे दे कि बताओ जेपीसी के कितने मेंबर्स हैं, ऑल ऑफ दैट. व्हाट इट मे गिव यू इज 2-3 इंफॉर्मेशन कमिटीज पे दिया, एक इंफॉर्मेशन जेपीसी भी दे देगा. द फर्स्ट टाइम जेपीसी वाज फॉर्म्ड इन 2018 ऐसा दे देगा कुछ स्टेटमेंट. सो इट विल जस्ट चेक वन पीस ऑफ इंफॉर्मेशन रिलेटेड टू जेपीसी. Another second statement may be about estimates committee of the parliament consists of 15 members from Lok Sabha, 7 from Rajya Sabha. Is this correct? No, it consists of all the members from Lok Sabha, 30 members all from Lok Sabha. So you should keep that in mind. Another thing which you should do related to the committees is that in certain committees, the speaker or the presiding officer is appointed as the chairperson by default. So you should know about those committees. इसके beyond आपको कुछ और information collect करने की जरूरत नहीं है इन committees. I can give it to you in writing. इससे ज्यादा कुछ और यूपीएससी नहीं पूछेगा. Also do remember one thing. यूपीएससी के अगर आप पिछले 20 साल के पेपर उठा के देख लेंगे, I am not even saying 10 years, 20 years, you will find that UPSC usually does not focus on asking questions related to parliamentary functioning. It asks either mains questions on analytical issues related to parliamentary functioning. It will ask questions related to disruptions or challenges associated with functioning of parliamentary committees. It would never ask questions in the prelims examination or even in the mains examination on the nitty-gritties of parliamentary functioning. वो बहुत कम होता है. Usually it is less. Also, another thing which I would recommend you should read about is the expunging of the remarks from the parliamentary proceedings. One, because it has been in news very recently. Also, you must know, a few months back, Parliament revised the list of words which are not supposed to be included into the records of the Parliament if they are mentioned by the members of the Parliament. So that also you should read, because those are decided according to the rules and the procedures of the parliamentary functioning. करंट अफेयर्स के अंदर ये सब चीजें बड़ी बड़ी छोटी छोटी इंपॉर्टेंट हैं. तो जो इंडियन एक्सप्रेस एक्सप्लेन्ड आर्टिकल्स आ रहे हैं ना, आपको मैं गारंटी से कह रहा हूं कि उसमें से लिटरली 60 to 70% क्वेश्चंस बन रहे हैं आजकल यूपीएससी के अंदर. इग्नोर इट एट योर ओन कॉस्ट, है ना, दैट सेट ऑफ आर्टिकल्स. सेकेंडली, जो आपका हिंदू के अंदर टेक्स्ट एंड कॉन्टेक्स्ट एंड जो वो पूरा एक्सप्लेन्ड आर्टिकल्स हिंदू के भी आते हैं, these are the most important things which you should cover. ये तो कंपल्सरली आपको सारे इंडियन एक्सप्रेस के एक्सप्लेन्ड आर्टिकल्स एक साल के पूरे पढ़ के जाने चाहिए, बिकॉज number of questions will be framed from that, not only in polity but in geography, in economy, in history, you know, so many things can, because उससे ज्यादा better content कुछ हो ही नहीं सकता for UPSC the way they are framing those particular articles. So I would seriously suggest कि आप वेबसाइट पे जाइए, उनकी सारे इंडियन एक्सप्रेस के एक्सप्लेन्ड आर्टिकल्स अगर आप कवर कर सकते हैं, अगर आपने पहले नहीं किए हैं तो यू शुड डू दैट, है ना. अगर आप इतनी भी एक्सरसाइज कर लेते हैं करंट अफेयर्स के लिए, एक्चुअली दैट विल बी मच मोर बेटर देन गोइंग थ्रू एनी ऑफ द मंथली मैगजीन्स एक्सेट्रा एंड ऑल ऑफ दैट एंड स्टफ, बिकॉज टू रिटेन दैट मच कंटेंट विल बी वेरी डिफिकल्ट. दैट इज रिटन स्पेसिफिकली टारगेटेड टुवर्ड्स द ऑडियंस ऑफ यूपीएससी. एनीवे, सो दैट इज अबाउट द पार्लियामेंट्री कमिटीज. ये पढ़ लीजिएगा. लॉट ऑफ दिस इज एनालिटिकल इंफॉर्मेशन that which we have already discussed related to parliamentary committees. Now one more topic probably which we can cover is, okay, we have covered this subordinate and delegated legislation also. I have discussed with you, है ना. इसके अंदर देखिए ये सब चीजें लिखी हुई हैं. Circumstances where delegated legislation would be invalidated. One is if it violates fundamental rights, of course, because we know under Article 13 no rule can be made, no law can be made against the fundamental right. Second, if it is ultra vires of the provision of the Parent Act itself, of the parent law. Third is if the executive does not have the legislative competence, मतलब पार्लियामेंट या लेजिस्लेचर ने उनको पावर्स ही नहीं दी थी रूल्स बनाने की, एग्जीक्यूटिव ने रूल्स बना दिए. Fourth is a delegated legislation can also be struck down if it is arbitrary or unreasonable in nature. It basically transgresses constitutional limits, or it cannot provide for retrospective application. So it should not be applicable retrospectively unless if the parent law itself is allowing that. And the Supreme Court has held that it cannot delegate its essential legislative functions to the executive branch. मतलब कि the legislature cannot tell the executive कि तुम पूरी law ही बना दो. They can only tell the executive to make the details of the law, not the entire law itself. So those are the reasons or circumstances in which a delegated or subordinate legislation would be declared as unconstitutional. एक और topic maybe we can just cover before we call it a class. Office of profit. ये जल्दी से discuss कर लेते हैं. What is office of profit? Now you must know that in order to be elected as a member of parliament, president of India, vice president of India, or governor of a state, you should not be holding any office of profit. What is an office of profit? An office of profit is a profit where the office holder or the position holder may be entitled to some kind of benefits, pecuniary benefits, as a result of holding that particular position. That is what is called as office of profit. In Indian constitution, there is no definition which has been provided of office of profit. See, Article 102, Clause 1, Subclause A says that if an MP holds an office of profit, then he shall be disqualified from contesting the elections as well as continuing as a member of the parliament. Similar provisions have been given in Article 191, Clause 1, Subclause A. Constitution of India does not provide the definition of office of profit. Please understand the basic reasoning behind including the office of profit. The logic is that in the 16th, 17th century, the king in Britain started to offer certain positions to the members of parliament in his court so that he could win them over and so that he could save his own position. This way, the parliamentarians realized the entire parliament's independence would be compromised. So they introduced this concept of office of profit, that if you are a legislator and if you are not a minister, then you cannot hold any position in the government unless you are a minister. अगर आप minister हैं तो फिर तो अब parliamentary system की वो एक limitation है that you will have to be a legislator. But other than a minister, no other MP can hold any kind of a position under the executive so that they can become susceptible to pressure of the executive. Why? Because सबसे important काम क्या है किसी MP और legislator का? To hold the executive accountable, because they are the true representatives of the people, right? So therefore this office of profit concept was introduced. In India's constitution, there is no definition of office of profit. In the Indian law also, there is no definition of office of profit. So Supreme Court has of course taken the responsibility of defining what is office of profit. In a judgment, they have laid down certain principles that should govern whether a particular office is an office of profit or not. They have laid down certain principles that can be followed by the courts in future to determine if an office is an office of profit or not. है ना. तो ये मैंने कुछ principles यहाँ पर mention किए हुए हैं. You may read it also in the handout that I have shared with you. What is the philosophical basis? What is the concept behind office of profit? What were the conditions which were or principles which were laid down by the Supreme Court in a judgment according to which the courts may decide whether an office is an office of profit or not? You and I should not be applying these principles to decide whether an office is an office of profit or not. It is the function of the courts. But Supreme Court has laid down certain principles as far as deciding whether an office is an office of profit or not. Also, you must know about Prevention of Disqualification Act of the Parliament, Prevention of Disqualification Act 1959. In this Prevention of Disqualification Act, there are certain offices which have been mentioned which are exempt from being declared as office of profit. So if a person is holding the offices which are mentioned in this law in the exempted category, that person shall not be liable for disqualification as a member of the parliament for holding those offices. So time to time, the parliament revises this list which has been mentioned in this particular law, which is called as Prevention of Disqualification Act. So you must also be knowing about the incidents that happened related to Dr. APJ Abdul Kalam, and which involved Mrs. Sonia Gandhi in 2006, where where a petition had been filed that she should be disqualified from the membership of the parliament as she is holding an office of profit. What was that office? As chairperson of नेशनल एडवाइजरी काउंसिल. तो फिर कांग्रेस ने एक बिल इंट्रोड्यूस किया पार्लियामेंट के अंदर, दैट वाज टू इंक्लूड द ऑफिस ऑफ चेयरपर्सन ऑफ नेशनल एडवाइजरी काउंसिल एज एन एग्जेम्प्टेड ऑफिस फ्रॉम ऑफिस ऑफ प्रॉफिट, and that too with a retrospective effect. When this bill was given to the President of India, Dr. Kalam, at that point of time to approve, he used his suspensive veto power. And what did he do? He sent this bill back to the Parliament for their reconsideration. Because if you would know, the President of India can send a bill back to the Parliament for the reconsideration if it is not a money bill. And once the bill was sent to the Parliament, Parliament sent it back to the President. Then what is the option in front of the President? He'll have to approve the bill, and that is what he did. Right? So you must also know about Prevention of Disqualification Act and some of the issues related to the office of profit. So that is what another thing which you can refer. Is this clear? Any questions or any doubts on whatever we have discussed today? See, we have a lot of ground to cover. I mean, we'll be covering in the next 3 classes as well, but my objective here is to not necessarily give you just an information of whatever is there in your material or superficially just tell you about what has happened, because that would not serve the purpose. My idea is that if I can make you revise all those topics which have been covered in this year's PT365, so that in the prelims examination, you don't now once you go back home, it will just take you 10, 15, 20 minutes to revise all of these concepts. And we have discussed this in the class. It will be conceptually more clear to you, and you'll be able to you'll be in a better state to attempt the questions in the prelims as well. Any questions? Okay, thank you so much. I'll see you tomorrow. This handout will be uploaded on your platform, so you may download it from there.